Good evening, students. Welcome back. Sounded like a school. So we'll revisit what we did yesterday. Okay. So this is about first we ended preamble fraternity. Okay. And how the Supreme Court also in Indra Sani case highlighted that reservation would bring in more fraternity in the society by overcoming the socio-economic gap. Okay. Then we have part 1 of the constitution. So part 1 of the constitution has article 1, article 2, article 3 and article 4. What is article 1? Two dimensions of article 1. India, that is Bharat, shall be a union of states, and in states union territories are not included here. But the second part of article 1, the territory of India shall comprise of Lok Sabha, Raj Sabha, this states, union territories and other territories that may be acquired. Actually, I was teaching article 79 somewhere. So the Parliament of India comprises of Lok Sabha, Raj Sabha and the President. President is not a member of Parliament, but he is part of the Parliament. Why he is part of the Parliament? Because what is the prime function of Parliament? To make laws. Okay, and if you cannot, law cannot be made without the approval of President. Okay, so Article 1 of the Constitution says that India, that is Bharat, shall be a union of states. Territory of India term is a wider term which includes states, union territories as well as other territories that may be acquired time to time. Article 2 of the Constitution deals with those territories that are not part of India. Parliament may by law establish new states or admit them into Indian Union or such terms it thinks fit. Okay. Article 3 is very important. It empowers, who is empowered to create a new state? Huh? Only Parliament. Okay. So only Parliament can create a new state. Okay? Only Parliament is empowered to create a new state. And how a new state can be created? बताइए चलिए. By law मतलब. So they'll ask, what is your opinion about violence against women? Bad. Huh? So you'll say by law. How? Good evening, sir. How are you? Shashidhar Pathak. I am doing good. Anyways, हाँ बताइए. So how a news? हाँ. Okay, so the recommendation of the state president is necessary before the bill can be introduced in parliament. And before giving such recommendation, it is mandatory for the president to seek the views and the opinion of the state that actually would be affected by the bill. So the bill is referred to the state legislature, they give their opinion within the specified time, and the opinion rendered by the state is not binding, but taking opinion is binding. Okay, after that the president gives go ahead to the bill, and the bill can be introduced in which house? Either Lok Sabha or Rajya Sabha. Okay, and the parliament goes ahead and creates a new state. Does that lead to a change in the constitution? Yes, change is there, but it is not seen as an amendment under Article 368, because if you what you call make a new state, you amend Schedule 1 of the Constitution as well as Schedule 4. Schedule 4 deals with the seats in Rajya Sabha, and Schedule 1 deals with list of states and union territories. Okay, so that is something which we did yesterday. Okay, so now Article 3 we have done. What is Article 4? So any law that is passed under Article 2 and 3 shall not be deemed to be a constitutional amendment under Article 368 of the Constitution. Okay, so this is the thing. Now we will see briefly, one thing is left, that is reorganization of states in India. Okay, reorganization of states in India. हाँ बताइए, डाउट है तो बताइए क्या है। हाँ हाँ बताइए क्या मतलब है। आप बोलिए। He is asking a question that if a bill, what is the meaning of this statement that a bill, the views of UT shall not be ascertained. So when you are affecting, a bill is affecting a state, the bill shall be referred to the state legislature. If a UT has a legislature and if a bill is affecting the UT, it shall not be necessary to refer to the legislature of union territory. Why? Because UTs are unions territories. Even if they have legislature on all the three lists, the parliamentary law shall prevail under all the circumstances. Even if a UT has a legislature, three UTs have legislature, Delhi, Puducherry and Jammu and Kashmir, then also the law passed by parliament on all the three lists shall be prevailing over the law passed by UT legislature. So you are getting this? बताइए. So if for example a bill is drafted by Ministry of Home Affairs that this bill will include 7 districts, क्योंकि उस बिल में लिखा होगा ना, if you are creating a new state, which all districts will be included, it will be written in the bill. Now in the parliament there is an amendment to the bill, 2 new districts are included. So any amendment that is later done to the bill shall not be necessary to refer to the legislature to ascertain its views. कुछ 368 है ही नहीं इसमें. 368 की बिल एक ड्राफ्ट हुई कि आंध्र प्रदेश इज बाइफर्केटेड इनटू आंध्र एंड तेलंगाना, तो उसमें लिखेंगे ना विच ऑल डिस्ट्रिक्ट्स ऑफ तेलंगाना विल कम अंडर, Andhra Pradesh will come under Telangana. Now the bill was sent to the state legislature, it gave its opinion. When the bill was introduced in parliament, they made certain change. 2 more districts were included. So bill was actually amended. So there was an amendment introduced to the bill in either house. Then again the views of state legislature will not be necessary every time you make a change in the bill. Only once you refer, that is more than enough. Okay. Now we will see reorganization of states in India. अब देखिए, मैं तो चाहता हूं कि क्वेश्चन लूं. Okay, so how small states may give rise to capital dispute? The biggest example is Chandigarh. Chandigarh was developed as among the few cities, only few cities that we actually developed post independence. Otherwise all the Chandigarh, Greater Noida, Greater Hyderabad and Noida. Otherwise all the cities that are already bursting with seams. So when Chandigarh was developed as a planned city and Haryana and Punjab, they were bifurcated, then what happened? Both the states were eyeing for the capital, that is Chandigarh. So for administrative convenience, it was given a joint capital, that is Chandigarh and Haryana. Haryana and Punjab, both the states. So the question is that how can small state may give rise to capital dispute? If you are creating a new state actually, so obviously if you are bifurcating, whenever you create a new state, the boundary of a state will be reduced. Internal, some or the other state has to give away its boundary, na? If you are readjusting, some or the other state's land will be taken. You cannot create new land कि 100 किलोमीटर और हो जाए, ऐसा तो पॉसिबल नहीं है. सो ऑब्वियसली इफ यू आर क्रिएटिंग अ स्मॉल स्टेट, दे विल बी वाइंग फॉर द कैपिटल. They would like to have the capital. So it may give rise to capital dispute, or different parts of the state may like to have capital at their place. Why? Because it will lead to economic boom. So definitely this happened in Andhra Pradesh. There was a tri-capital and then the case went to High Court and there's so much dispute. Okay, so this may give rise to capital. And there are few more questions actually, but the point is ki we have to be a bit more judicious out here. So what, sir, you have concurrence and consultants. What is the difference between concurrence and consultants? Concurrence and consultants? Concurrence means unki marzi se. Consultant matlab by the permission, by exchange of opinion which is binding. Consultation means just an exchange of opinion or views. Although the meaning of term consultation is completely different in Article 124, where with respect to appointment of judges of Supreme Court and High Court, Supreme Court has ruled that the term consultation means binding. Otherwise, normally wherever in the constitution term consultation, it means exchange of views, and concurrence means you must abide by the views, they must arrive at a consensus. Okay, now reorganization of states, see, they will basically concerned about Article 3. Reorganization of states, which state created on what date, it is a long list of facts for UPSC, they will not be asking. If you are taking a state PSC exam, undoubtedly they may ask a question, what is your respective state day and when your state was created. Otherwise, UPSC will not ask all 28 states. Remembering all those facts are not necessary. So, after independence, the country was actually classified into 4 groups. Part A, governors' provinces, those provinces which were directly ruled by the Britishers. Part B, princely states with legislatures. Part C, you were having some places like what you call, you have centrally chief commissioners provinces, and some other princely states were also there. And part D was Andaman and Nicobar. Actually, Britishers were very much what you call interested in keeping Andaman and Nicobar, because it is at one of the most important sea lanes of communication. From state of Malacca, you have till Babel Mandeb and Suez Canal. It is one of the most important sea lane of communication. You see in Indian Ocean, Diego Garcia, the base of United States. So you have Falkland Island, United Kingdom, right there near South America. So the point is that many of the countries, India also has a base in Tajikistan, air base. So the point is that many of these colonial powers have already kept some other places in oceans where they have not left. They are actually based. So Britishers also wanted to have Andaman and Nicobar. But due to strategic reason and also historical reason, many of the freedom fighters were put in. So we were adamant, and finally we got Andaman and Nicobar. So post-independence, it was classified into group A, B, C, D category. Okay. So there was a constant demand to create states on the basis of language. Okay. So when states were created on the basis of language, then, you know, at that time the thinking was that if right now the country has come into being in true sense, independence, if we create states on the basis of language, it will lead to linguistic chauvinism. Chauvinism means being very particular about any identity. It can be male chauvinism, it can be linguistic chauvinism, or any other forms of chauvinism. So there will be too much of what you call, if you see the exchange of letters between Nehru and Ji and other political leaders, the government was of the view that we may create states on the basis of language, but we can wait for a while. So then the demands were coming up that yes, there is a provision in the constitution why states cannot be created on the basis of language. So finally a Dhar commission was set up. Okay, so Dhar commission made a recommendation that at this state it is not feasible for national integration to create states on the basis of language. The report was widely resisted. So again, this time, first time Dhar commission was a Government of India commission, but second is the JVP committee, Jawaharlal Nehru, Vallabhbhai Patel and Pattabhi Sitaramaiah. What is the difference between Dhar and JVP committee is actually that this was created by Indian National Congress. JVP committee was created by Indian National Congress, and any committee by Indian National Congress actually was of great significance, but Congress was actually ruling. But UPSC may trap you by asking a minute question that JVP committee, these are the 3 committees created by Government of India to look into reorganization of states on the basis of language. So JVP committee is one such committee which is not created by Government of India but created by Indian National Congress. You are getting my point. So you have first, you have Dhar commission, then you have JVP committee, and finally you have, when after JVP committee also rejected, no, states cannot be created on the basis of language, it will lead to linguistic chauvinism, we can wait for a while, future we can look into that. Then we all know that somebody from Andhra Pradesh, freedom fighter, Potti Sriramulu, he sat on a hunger strike. After 56 days of hunger strike, he died in demand for the creation of Andhra Pradesh out of the the Madras province. Telugu speaking areas should be out. So there was huge violence after the death of Potti Sriramulu. So the Government of India was forced to create Andhra Pradesh. And once the the parliament went ahead and created Andhra Pradesh, similar demands started coming from everywhere. So the government constituted State Reorganization Commission under the chairmanship of Justice Fazle Ali, Hirdaynath Kunjru and K.M. Panikkar. Three people were there. Fazle Ali was the chairman, so it is called as Fazle Ali Commission. The commission predominantly said that one language, one state formula is not accepted. One language, one state formula is not accepted, but for the first time there was a commission which says that we may go ahead and create state on the basis of language if economic significance, administrative issues, these issues can be managed, then we may create state on the basis of language, but one state, one language formula is not accepted. So this was at least for the first time a commission making a recommendation that states can be created on the basis of language. So the government went ahead and two bills were introduced in Parliament, 7th Constitutional Amendment Act and State Reorganization Act 1956. So now some of you must be thinking that, sir, when you create a new state, there is no need to have a constitution amendment. So why 7th Constitutional Amendment Act bill was also introduced? Reason being, is it possible in a country like India to have the entire population speaking only one language in a state? There will be some, whatever way you calculate, some or the other linguistic minorities would be left there. Some of the other linguistic minorities in the state would be left there. And once you create, for example, you join an organization, start preparation or anything, there is that new energy, vigor and what you call life. Spirit is there. And that new, what you call, a sort of, what you call power is to you. So, whenever a new state would be created on the basis of language, there may be rising tide of linguistic chauvinism and the aspirations of linguistic minorities may be subdued. So, it was realized that when you are creating state on the basis of language, thank you. So, when we are creating state on the basis of language, what we are going to do? We are going to create a special officer for linguistic minorities. So for that and many other things, declassification of state, ABCD say delete kijiye, no, there will be states and union territories. From now onward, there will be no classification. There can be a common high court for two states, or there can be a common governor for two states. So many provisions in the constitution also required to be changed. So 7th Constitutional Amendment Act was also passed and State Reorganization Act 1956 was also passed. Okay, and what is State Reorganization Act 1956? It led to the creation of states and union territories. Okay, so getting my point. So 7th, अब क्या हुआ? दो offices बने. एक Article 350B Special Officer for Linguistic Minorities. Now you are creating state on the basis of language. There will be small pockets where there will be linguistic minorities. So since the state is created on the basis of language, there may be a tendency to actually suppress the aspirations of linguistic minorities. So a special constitutional officer was created. Special Officer for Linguistic Minorities, Article 350, capital letters B. He will look into the aspirations of linguistic minorities and report through the Ministry of Minority Affairs to the President about the condition of linguistic minorities and safeguarding their rights. And this office, in all the text it is written, it is headquartered in, where is Special Officer of Linguistic Minorities? Where is the headquarter? Allahabad. But from 1st June 2015, it has been shifted to New Delhi, behind UPSC. Okay, so this is an important fact. And Joint Secretary Nigar ma'am, she is the Special Officer for Linguistic Minorities. So Special Officer for Linguistic Minority is a constitutional office to safeguard the interest of linguistic minorities. At the same time, Article 350, capital letters A was also added, that it shall be the duty of state to provide education to the children of linguistic minorities in their mother tongue up to primary level. Because at primary level, if you force them majority language, their language will actually change. So to safeguard the interest of linguistic minorities, states were created through an ordinary law, State Reorganization Act 1956, passed by simple majority. But these changes in the constitution, doing away with the classification ABCD, creating the Office of Special Officer Linguistic Minorities, and constitutional mandate on the state, that state shall provide what you call education to the children of linguistic minorities. जो state के linguistic minorities है, उनके बच्चों को in primary, up to primary level in their mother tongue. This is one of the direction in Article 350, capital letter A of the Constitution. Okay, so this was added through a constitutional amendment, because you cannot add a provision in the Constitution without a constitutional amendment. So that, and one more thing, so still what is actually this, I'll be dealing in Article 30, linguistic minority versus religious minority. So there can be many minorities. For example, somebody is wearing a red t-shirt in the class, so in color he may be a minority. Somebody may be a sexual minority, somebody may belong to Puducherry, so there may be only one person from Puducherry in the class, so that minority. But what kind of minority is recognized in the constitution? Article 30 of the constitution recognizes only two kinds of minorities, linguistic and religious. So there is a very, very important case pending in Supreme Court, as if now linguistic minorities are determined on state level. So every state determines who is a, we will do this again in Article 30, but since we are talking, why not talk here? So linguistic minorities are determined on state level. So there can be, you see, and once they classify a community as a linguistic minority, they can open their medical college and reserve 50% seats. Okay, so linguistic minorities are classified at state level, religious minorities are classified at national level. It is only the national union government which has classified the last religious minority to be classified by JANS in 2014. And National Commission for Minorities Act and National Commission for Minority Educational Institution Act empowers the union government to declare a religious minority. Now a petition is pending in Supreme Court very strongly arguing that Hindus should be declared minority in states like Nagaland, Mizoram and Jammu and Kashmir, so that they can open their medical college and reserve 50% seats for the people belonging to that religious community. So, and this is a very valid argument. Most of the constitutional philosophers, Faizan Mustafa, the Vice Chancellor of Nalsar University, or most of the scholars are of the view that this is a very genuine demand. So religious minorities can also be determined on the basis of state as the linguistic minorities. So we are still awaiting a Supreme Court verdict on this. It has challenged that provision of National Commission for Minorities Act which empowers the union government to declare a religious minority. So what all happened in reorganization? Initially there was a demand after independence to create states on the basis of language. Dhar Commission was established. Dhar Commission rejected the idea of states on the basis of language. There was more protest. So Congress Party committee was constituted. Jawaharlal Nehru, Vallabhbhai Patel and Pattabhi Sitaramaiah. Second committee. It also rejected the idea of states on the basis of language. Then a man called Potti Sri Ramulu. He was a freedom fighter also. He sat on a hunger strike demanding the state of Andhra Pradesh out of Telugu speaking areas out of the Madras province. So since he died on the 56th day, there was huge violence. So the parliament, a bill was presented by union government led to the creation of Andhra Pradesh. Once Andhra Pradesh was created, there was fanning of fire and other protests started. So the government constituted Justice Fazle Ali Commission under the chairmanship of Fazle Ali with two other members, Hirdaynath Kunjru and K.M. Panikkar. These were the two other members. They sat down and finally said that, okay, states may be created on the basis of language, keeping economic, administrative and national integration factors in mind. But we reject the formula of one language, one state. Otherwise, from Rajasthan till Jharkhand, there would be only one state. Hindi is spoken with different dialect. Okay, so that was rejected. And on the recommendation of Fazle Ali Commission, 7th Constitutional Amendment Act was brought along with State Reorganization Act 1956. State Reorganization Act 1956 created 14 states and union territories, and 7th Constitutional Amendment Act added Article 350 capital letters A, providing a duty on the state to safeguard the interest of linguistic minorities, and Article 350B, special officer for linguistic minorities. At the same time, State Reorganization Act 1956 also created zonal councils. Now that you are creating states, they must develop the habit of cooperative working. This is what Mr. Nehru said in Parliament. कि we are creating zonal council, मतलब zone में बांट के states को कि वो आपस में मिलजुल कर काम करे. Home Minister is the chairman and chief ministers by rotation are the chairman. We'll see this. One thing you tell me, if new states are created, then what would be one other dispute which is very likely to happen? अगर नया state हम बनाएंगे तो water dispute. So Interstate Water Dispute Act 1956 was also passed. Interstate Water Dispute Act 1956 was also passed in the same year, because now that you are creating new states, water dispute is likely to happen. And all these things we will see exhaustively in federalism. One thing more, in the morning batch also I told that whenever I mention something from the outside, It is not that it will not be coming. It will definitely be coming again, and we will, federalism is one such topic that we'll be dealing for 6 hours, at least 2 classes. If something, I feel that while teaching something, a brief mention of other thing will make the whole discussion holistic, then only I make a statement over there. That doesn't mean, or if I randomly talk about a case of United States, it is not required. UPSC doesn't want you to know that. It is only just for discussion to bring as many examples so that you understand. I bring those. It is not necessary. UPSC knows that students from diverse background are coming for the examination. Somebody has not even, somebody doesn't even know what is the difference between constitution and ordinary laws. Getting my point? So without a shadow of doubt, they do not expect you to be expertise. This syllabus says capital letters mein basic understanding of these topics. They will never ask you to the level we have discussed. Maximum they will ask you what is the process to create a state and what are the benefits of creating smaller states. So what are the challenges? Isse zyada they will not be asking. Okay, so I just bring those points that those, actually there are multiple reasons. First, it will bring a holistic view. Second, if you read somewhere, you will understand. Many a times, if I read a term in newspaper quite frequently, I use in the class so that you, when you read the newspaper, you are already familiar with the term. And third, there are students also who have diverse optionals. Some of them have law, some of them have public administration, some have political science. So, कुछ अगर मिल रहा extra, तो उसके लिए आपको चिंता नहीं करनी. You don't need to write those things. Okay, so they will not be asked. Basic they want you to know. So can I ask few questions before making a dictation? Okay, so which committee, which commission finally recommended the creation of states on the basis of language? Fazle Ali Commission. What were the ramifications of Fazle Ali Commission? Fazle Ali Commission की recommendation पर क्या हुआ? Anybody can say me from the back? Answer me please. कोई आंसर दीजिए. हाँ बताइए. The classification of states into group A, B, C, D was dismantled, repealed, removed, and new states were formed. And what other things seventh constitutional amendment did? So Article 350A. अब मैं एक बार हिंदी में बोल देता हूं. स्टेट की ये जिम्मेदारी होगी वो बच्चे जो लिंग्विस्टिक माइनॉरिटीज के बच्चे हैं उनको प्राइमरी लेवल तक उनकी मातृभाषा में शिक्षा दी जाए. इट इज द ड्यूटी ऑफ स्टेट टू प्रोवाइड एजुकेशन अप टू प्राइमरी लेवल टू द चिल्ड्रन ऑफ linguistic minorities. For example, this is a state where Hindi is spoken. Okay, so there are pockets in Delhi where you will find diversity. So people from Tamil Nadu, people from Bengal, people from Andhra Pradesh are there. So there are schools. You have Delhi Tamil LM Association right in DTEA school is there in Pusa Road. Then you have near IP College, you have Bengali school. Okay, so the children of linguistic minorities, the state shall try to provide them education at least up to primary level in their mother tongue so that they don't forget their mother tongue and their language is also preserved. So this is a constitution. And why this was added through 7th Constitutional Amendment Act? क्योंकि उससे पहले जरूरत ही नहीं दिखी. उससे पहले the states were not created on the basis of language. उसी वक्त ऐसी जरूरत फील हुई. At that time it was felt. And also a special constitutional office was created. एक नया कॉन्स्टिट्यूशनल ऑफिस बनाया जिसका यह काम होगा कि लिंग्विस्टिक माइनॉरिटीज के बच्चों का ख्याल, उनकी सेफगार्ड और लिंग्विस्टिक माइनॉरिटीज के बाकी इश्यूज को देखना. A new constitutional office was created to look into the interest of linguistic minorities. And in every state you have linguistic minorities. For example, some places Urdu speaking population is a linguistic minority. For example, some places Bengali speaking population is a linguistic minority. For some places Tamil speaking population is a linguistic minority. As if now the term minority, this question has been asked by UPSC and many exams, that the term minority has not been defined in the Constitution. What is the present status? Any community that is not majority is taken as minority, and who classifies? Linguistic minorities classified by the state governments, and national religious minorities are classified by the union government. Multiple petitions are pending in Supreme Court to empower the state governments also to declare religious minorities. If you have you're getting my point. And what is another thing? We will see this again in federalism. Federalism क्या, center or state? So federalism में executive power relation, administrative relation, financial relation, legislative relation, zonal councils, national emergency, president rule, financial emergency, interstate water dispute, interstate council, all these cooperative federalism, all finance commission, all these things we will again see in federalism. Okay, for the time being, what is the purpose of special officer for linguistics? Where is the headquarter? Headquarter is in New Delhi. It has been shifted from Allahabad to New Delhi. And what is the purpose of special officer for linguistic minorities? To safeguard the interest of linguistic minorities. Look ki what are the constitutional safeguards provided to them और वो actually कर क्या रहे हैं. समझ रहे हैं ना? स्टेट क्या लिंग्विस्टिक माइनॉरिटीज के साथ कोई दुर्व्यवहार या डिस्क्रिमिनेशन कर रहा है? क्या स्टेट गवर्नमेंट अपने लिंग्विस्टिक माइनॉरिटीज को अच्छे से ट्रीट कर या नहीं? क्योंकि लैंग्वेज इज द मोस्ट इंपॉर्टेंट करियर ऑफ कल्चर. लैंग्वेज इज द मोस्ट इंपॉर्टेंट करियर ऑफ कल्चर. इट इज वे बियॉन्ड रिलीजन. Getting my point? You see in Delhi, any person, two people speaking same language become friends at a very faster pace. Then any other identity is subdued because language is a very sensitive thing. Very, very sensitive. It is the most important career of culture. The people who speak similar language have most likely to have similar cultures. Okay, so getting my point? So language is a sensitive issue. A state may try to suppress the aspirations of linguistic minorities. So a constitutional guarantee is there that there will be a constitutional officer to safeguard their interest, and every year report to the president about the status of linguistic minorities in various states of India. Getting my point? And who declares a linguistic minority? State or center? State declares a linguistic minority. So reorganization, after that many other states were created. Okay, so ye safar shuru hua, then many other states you have recently, Jammu Kashmir was bifurcated into 2 union territories. Before that you have June 2014, Andhra Pradesh was bifurcated into Andhra Pradesh and Telangana. Before that in the year 2000 you have Jharkhand, Chhattisgarh and Uttarakhand. So states have been created time to time. Okay, so that process will go on. There are demands also, Gorkha land. Okay, so there is Gorkha territorial administration को कुछ power दे दिया है कि ठीक है, you don't make a state but you have certain powers by an act of West Bengal legislature. So you have Bundelkhand area. Okay, that also there is a constant demand to have it as a state. Some areas comprising of Madhya Pradesh and Uttar Pradesh, that Bundelkhand area. Then you have Vidarbha region in Maharashtra. Then you have Saurashtra region in Gujarat. Okay, so ideas do come up and there are demands of states, but whenever the union government feels it feasible, it goes ahead and actually creates a, Telangana is an actually elevated plateau area, which is a landlocked area. Development was relatively less compared to other part of the state. So actually it was bifurcated. Andhra Pradesh was bifurcated into Telangana and Andhra Pradesh. Okay, so please write reorganization of states in India. नहीं, बिल्कुल नहीं, कहीं तो ये बिल्कुल नहीं. In Tamil Nadu you have Muslims. So many. I have friends from Delhi University. They speak Tamil. They have mother tongue is Tamil, but they are religious minorities. हाँ? अभी तक criteria, any community which is less than majority is minority. There is only one community which has not been given minority status, Jews. Otherwise, all the communities have already been given. Any community which is not Hindu has been given minority status. And who is empowered? Union government. As if now this criteria is followed. Okay, and their language and religion are different things. There are Tamil speaking Muslims which are minorities, but they speak Tamil. Language has nothing to do with religion. Language has absolutely nothing to do with religion. Language and religion, the people who came from Pakistan, okay, most of them speak Urdu. Okay, so Dr. Manmohan Singh, when he was addressing the Red Fort from the rampart of Red Fort, when he was addressing the country on 15th August, ANI photographer clicked the picture from back. The whole speech was written in Urdu. So language has nothing to do with religion. He has came from West Pakistan where he had his primary education in Urdu. Religion and language, Urdu it was born and brought, it has nothing to do with Arabic. Arabic is the language that is from West Asia. Okay, Saudi Arabia predominantly, but Urdu is purely an indigenous language. Okay, and many languages in Europe also has their roots in Sanskrit. Many languages, mother, matra, So many, Sanskrit is the mother of many languages. It's a beautiful language. Languages do not belong to a religion. Languages are important component of existence and culture. They don't belong. They are different things. So language and religion are two different things. So there can be linguistic minorities as well as religious minorities. Other minorities are also there. Sexual minorities. Supreme Court recognized in Nas Foundation case and Navde Chauhar case that consensual sex between adults in private of the same gender shall not be a criminal offense. So there can be sexual minorities, but what is minority that is actually recognized by the Constitution? Which minority is actually recognized by the Constitution? Linguistic and religious. And what is the current status? I have told you. Okay, please write reorganization of states. And online students, please ask your question in the query portal, because it is practically not feasible, possible that I may be answering them, okay, because we have to take the lecture. So you may ask at the portal and academic coordinator would be very, very beautifully answering, okay. And some of you from the class also ask questions in the portal. And sometimes they answer in the portal, I've seen. Anyways, please write reorganization of states in India. Post-independence, 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 there was constant demand, post-independence, there was constant demand to create states on the basis of language. To create states on the basis of language. The government of India in 1948, the government of India in 1948 the government of India in 1948 appointed Linguistic Provinces Commission under the chairmanship of the government of India in 1948 appointed Linguistic Provinces Commission under the chairmanship of Mr. S.K. Dhar. Mr. S.K. Dhar. S.K.Dhar. S.K. Dhar. Next you write, the commission recommended that administrative convenience, the commission recommended that administrative convenience rather than language should be the basis of linguistic reorganization. Linguistic reorganization. Next you write, the recommendations created resentment. The recommendations created resentment and Congress constituted a 3-member committee known as 3-member committee known as JVP committee. JVP capital letter में लिखिए, JVP committee. JVP committee. ब्रैकेट में लिखिए जवाहरलाल नेहरू, वल्लभ भाई पटेल, जवाहरलाल नेहरू, वल्लभ भाई पटेल, पट्टाभी सीतारमैया, PATT, जवाहरलाल नेहरू, वल्लभ भाई पटेल, पट्टाभी सीतारमैया, PATTABHI. Actually, they don't deduct marks for names, spelling and all. Okay, don't worry. Okay. Pattabhi Sita Ramya. Sita RAMAYY Ramya. ठीक है? Close the bracket and write the committee rejected language as the basis of states reorganization. The committee rejected language as the basis of states reorganization. The committee rejected language as the basis of states reorganization. Okay? Full stop. Next point, right? In October 1953, the government created through parliament state of Andhra Pradesh. Government created through parliament state of Andhra Pradesh after there was agitation government through parliament created the state of Andhra Pradesh after there was agitation in the backdrop of the death of Potti, P-O-T-T-I, please write P-O-T-T-I, Sri Ramulu. Potti Sri Ra, S-R-I-R-A-M-U-L-U, Sri Ramulu. Is it that tough? P-O-T-T-I space S-R-I Sri R-A Ra M-U-L-U, Sri Ramulu. Okay? So after the death of Potti Sri Ramulu, demanding the creation of Andhra Pradesh. Demanding the creation of Andhra Pradesh. Okay? Then you write, after the creation of Andhra Pradesh, protests intensified. After the creation of Andhra Pradesh, protests intensified. Full stop. ठीक है? Next line you write, the government of India then appointed a 3-member state reorganization commission. The government of India then appointed a 3-member state reorganization commission. Okay? Comprising of Justice Fazle Ali as the chairman comprising of Justice Fazle Ali as the chairman and other two members as K.M. Panikkar and K.M. Panikkar, P-A-N-I-K-K-A-R. Fazle Ali as the chairman and other two members as Fazle Ali as the chairman and other two members as K.M. Panikkar, P-A-N-I-K-K-A-R. K.M. Panikkar, K.M. Panikkar, okay? And H.N. Kunjru, H.N. K-U-N-Z-R-U, Kunzru, okay? K-U-N-Z-R-U. K.M. Panikkar and Hridaynath Kunjru naam tha actually inka. So H.N. Kunjru. So who was the chairman of State Reorganization Commission? Fazle Ali. Who was the chairman of Linguistic Provinces Commission? अभी लिखा है एसके धर. अभी तो 5 मिनट भी नहीं हुआ है, एग्जाम तो नेक्स्ट ईयर है. अच्छा कुछ लोग इस साल, अच्छा आप लोग तो 2023 वाले हैं ना? हाँ, एनीबडी टेकिंग दिस ईयर? ओके ओके, समबडी इज टेकिंग दिस ईयर. ओके ठीक है, मोस्ट ऑफ यू आर टेकिंग नेक्स्ट ईयर. ठीक है, लेकिन नेक्स्ट ईयर भी तो आ ही जाएगा ना. हाँ, कैसे रुकेगा? रुका है समय. हाँ, सबसे बलवान है. हाँ, getting my points. Okay, so what did you write? H.N. Kunjru, K.M. Panikkar and Fazle Ali. Next you write the commission gave its recommendations. The commission gave its recommendations identifying 4 key factors. The commission gave its recommendation identifying 4 key factors for reorganization of states. Identifying 4 key factors for reorganization of states. Identifying 4 key factors for reorganization of, say, A, linguistic and cultural homogeneity. Linguistic and cultural homogeneity. Linguistic and cultural homogeneity. B, unity and security of the country. C, linguistic and cultural homogeneity, unity and security of the country. C, financial, economic and administrative considerations. Financial, economic and administrative considerations. लिंग्विस्टिक एंड कल्चरल होमोजेनिटी फर्स्ट पॉइंट है, मुझसे पूछिए, छूट गया तो रेज योर हैंड. सो लिंग्विस्टिक एंड कल्चरल होमोजेनिटी, यूनिटी एंड सिक्योरिटी ऑफ द कंट्री लिख लिया आपने. तीसरा पॉइंट लिखिए, फाइनेंशियल, इकोनॉमिक एंड एडमिनिस्ट्रेटिव कंसिडरेशंस, फैक्टर्स, कुछ भी. फाइनेंशियल, इकोनॉमिक एंड एडमिनिस्ट्रेशन. नेक्स्ट पॉइंट यू राइट, प्लानिंग and welfare of the people. Planning and welfare of the people. Okay. The recommendations of Fazle Ali Commission were broadly accepted. Write in English. The recommendations of Fazle Ali Commission were broadly accepted. The recommendations of Fazle Ali Commission were broadly accepted and 7th Constitutional Amendment Act, 7th Constitutional Amendment Act, the recommendations of Fazle Ali Commission were broadly accepted, and 7th Constitutional Amendment Act along with 7th Constitutional Amendment Act along with what? State, बताइए, along with, पीछे से बोलिए कोई, along with, I want to travel there. I cannot leave anybody. आ रहे हैं तो समझना पड़ेगा, नहीं समझिएगा तो मैं घर जाके समझाऊंगा, ठीक है. Along with State Reorganization Act 1956 was passed by the Parliament. Along with State Reorganization Act 1956 was passed by Parliament. Okay. Along with State Reorganization Act 1956 was passed by Parliament. Next you write, the 7th Constitutional Amendment Act also created the office of, the 7th Constitutional Amendment Act also created the office of Special Officer of Linguistic Minorities, Special Officer of Linguistic Minorities, Article 350, Special Officer for Linguistic Minorities, Article 350 capital letters B, ठीक है. Special Officer for Linguistic Minorities, Article 350 capital letters B, and also added Article 350A, 350A. ओके, आर्टिकल 350A, ठीक है, डन है ये. अब आगे लिखिए, द ग्रुप ABCD classification, the group ABCD classification was done away with, the group ABCD classification was done away with and 14 states and 6 union territories, and 14 states and 6 union territories were created on November 1st, 1956. November 1st, 1956. Okay, November 1st, 1956. So this is the position. Okay, so this is with relation to state. We have done more than enough. Article 3, Article 1, Article 2, Article 4, what is the positive, what is the negative, what is the majority, what is, how states came into being, what are the commissions, and which recommended, which accepted, what are the grounds, what happens, everything. We also saw some constitutional, what Article 350A and B. Okay. So I told you that there is only one part where we'll be breaking the chronology, that is citizenship, which we'll do at end. Now we'll be starting the most important part, and many of you are already aware, because many of you are already preparing, and some of you every day and day in and day out you fundamental rights. Okay. So first of all, fundamental rights are in which part of the constitution? Part 3. Okay. Fundamental rights are in part 3 of the constitution, from which article to which article? Article 12 to article 35. Okay. So this year there was a question: fundamental right, legal right, statutory right, constitutional right. Okay. So there are some generic, see, fundamental rights from first of all, the question that was asked by UPSC, right to property is a legal right in India. Okay. This was a statement which has been broadly accepted as true. Legal, what is a right? What is a right? बताइए एक, what is a right? हाँ? Okay, rights are legal authority, claim. Okay, so rights in simple language are rights are legally protected interests. Okay, so rights are those interests which are legally protected. Okay, now, okay, now the Constitution of India has not defined anything as natural, okay, statutory, fundamental, constitutional. So okay, so the Constitution of India has not defined anything natural, statutory, fundamental and constitutional classification. Okay, they have not actually defined. But a general understanding is, natural right, though actually it is not defined in any law or any statutory provision or any executive order. Simple by the works of Rousseau and Locke, natural rights are those rights which are ordained on human beings by virtue of being born in human genus. By virtue of being born in human family, some scholars say that certain rights come to you. Okay, just a right to breathe, okay, or have clean air, or to an extent right to freedom of speech or expression, okay, or your life cannot be taken easily. So basic rights. So they are not actually defined, but natural rights, by just by virtue of being human being, you have certain rights. Which statutory rights are those rights which actually are created by a statute. Example, any right which is emanating from a statute or a piece of law. Okay, so जैसे right to information. Right to information is coming from Right to Information Act 2005. Or I can show you one more. Just a second. बीच में, these are not, but it will broaden your understanding. Okay, so you know the difference between ordinary law and constitution? Huh? Give me example of an ordinary law. Okay, CRPC, all these are okay. So for example, on your board you have Mahatma Gandhi National Rural Employment Guarantee Act. This is an ordinary law or this is constitution? Ordinary law. कोई doubt है? DOUBT कुछ भी नहीं. It says that section 3 of Mahatma Gandhi National Rural Employment Guarantee Act says that the government shall provide to every household whose adult members volunteer to, मतलब जिनको मन है, ऐसा नहीं कि सबको. Getting my point? Unskilled manual work of not less than 100 days. 100 days of such work in a financial year. So it is actually giving you 100 days of unstatutory right to 100 days of unskilled manual work. Yani, even if you don't have employment, the government guarantees that if you want to, you will be given at least 100 days of unskilled manual work. Which you cannot claim that no, I'll be working on robotics. Okay, so unskilled manual work, okay, a physical manual work that will be given to you, that is guaranteed by a piece of law. So this is a statutory right because it is promised by a statute. Similarly, you have Right to Information Act, which says that when you file an application within 30 days, you must be given reply on the information sought until it is exemption under section 8. There are certain provisions, we'll see that. So right to information, statutory right. Mahatma Gandhi National Rural Employment Guarantee Act provides for 100 days of unskilled manual labor. Okay, then you have, for that matter, Maternity Benefit Act provides for 26 week of paid maternity leave. So it is provided by a statutory provision, so it is a statutory right. Although the provision is there in Article 42, but that is directive principle. The state may or may not adhere to that. So natural rights are not defined. They are actually the works of philosophers, that just by being born to human genus, इंसान बनकर पैदा होने की वजह से कुछ चीजें तो आपको मिलनी ही चाहिए. You must be given certain rights by virtue of being born in human genus. That is natural right, but they are not codified per se in India. Statutory rights are those rights which are originating from a piece of ordinary law. So you have Mahatma Gandhi National Rural Employment Guarantee Act providing for 100 days of unskilled manual labor. इतना काम तो आपको मिलेगा ही मिलेगा. Then you have fundamental rights. Those rights which are found in part 3 of the Constitution are fundamental rights. Those in part 3. Normally across the world, there is a definition that all those rights which are inside the Constitution are constitutional rights. But in India, since we have a classification within the Constitution, also you have two categories of rights. One, rights which are in part 3, other rights which are outside part 3. So rights which are outside part 3 are, एक सिंपल डेफिनेशन आप ही बताइए पूरी दुनिया में क्या होगा. व्हाट शुड बी द सिंपल डेफिनेशन इन द वर्ल्ड? अ कॉन्स्टिट्यूशनल राइट इज वन विच इज कमिंग फ्रॉम द constitution, but in India we have a separate classification. There is part 3 where you have fundamental rights which are in part 3, and outside part 3 you all know that is right to property. Article 300 capital letters A, no person shall be deprived of his property save by authority of law. So Article 300A of the Constitution actually is not in part 3, outside part 3 in Article 300A. Okay, and this Article 300A is actually a constitutional right. So natural rights are those rights which are by virtue of being born in human genus. It is a settled understanding among scholars that at least you should have the right to eat, or right to access clean air, or to speak, or to practice any religion. These are the basic rights that must be given. But you have statutory right coming from an ordinary law, fundamental rights in part 3 of the constitutional right under Article 300A of the Constitution, that is outside part 3 but inside Constitution. It is outside part 3 but inside Constitution. At back you are understanding, outside part 3 but inside Constitution. So we have अब एक नया यूपीएससी ने इस बार शगुफा दिया, legal right. Okay, they asked the trapping question. They said right to property is a legal right in India. Right to property, क्योंकि अभी तक discussion है constitutional right, statutory right and fundamental right. They asked the trapping question. तो यहां इस डेफिनेशन से क्या पता चलता है? व्हाट इज अ राइट? Rights are legally protected interests. So most of the books you will find statutory rights are legal rights. This is a common sense which you will find in most of the books, that those rights which are coming from ordinary law are legal rights. But it is not strictly per se, because legal is a general term. Any right which is legally protected is a legal right. So right to property, being a constitutional right, is also a legal right, because it is a generic term to be used. And I made them write last year कि rights are legally protected interest. Even for fundamental rights is a legally protected interest. So right to property is also a legal right, and that legality is coming from constitution. So legal is a generic term to be used. So what are the classification you have? Statutory right by ordinary law, fundamental right, those in part 3 only, ONLY, and those outside part 3 but inside constitution are constitutional rights, and legal right is a general term. Although in many books you will find that only statutory rights are legal rights. Okay, that is why this question became extremely what you call controversial this year, because ordinary rights are normally called as legal rights. Okay, but legal is a general term. Anything that is valid by law, and constitution also is a law. It is actually fundamental law. It is actually fundamental law of the land. So so this answer UPSC will give after the Shrad. It is legally protected interest. Okay, so rights are legally protected interest. So right to property is also a legal right in India. Okay, now why do we need fundamental right? So one such statement which is very dear to me, literally I have made them write in every batch. Sarvapalli Radhakrishnan said this, that fundamental rights are India's pact with the civilized world. And this I don't know, I read in some book, I made them write 10th October, जब भी UPPSC था, they asked the trapping question that fundamental rights are India's pact with the civilized world, and they opted for Jawaharlal Nehru first option, Rabindranath Tagore second option, Sardar Patel and Sarvapalli Radhakrishnan. 99% of population went with Jawaharlal Nehru or Rabindranath Tagore. But this actually was said by Dr. Sarvapalli Radhakrishnan, that fundamental rights are India's pact with the civilized world. कैसे, क्या समझते हैं इससे? What do you understand by the statement that fundamental rights are India's pact with the civilized world? Chal. To? Okay, so overall development of human individual, you need fundamental rights. Okay, anything beyond? Why they say that fundamental rights are India's pact with the civilized world? Pact का मतलब समझते हैं? Agreement with the civilized world. It is not that easy and not that plain. PLAIN. PLAIN ही मत समझ लीजिएगा. Okay. Okay, it is a kind of social contract. Marriage is a social contract. Okay. Okay. It has, how it has, very good, how it has civilized us. क्या नाम है आपका? जी आदर्श जी बताइए. How it has civilized us? You are going in the right direction. थोड़ा और प्रकाश डालिए, बताइए. चलिए, एक इन्होंने बहुत बहुत अच्छी बात बोली. Without fundamental rights, we won't be a democracy. सुनिए, what are fundamental rights? They are restriction on the state or they are positive rights? Most of the fundamental rights are restriction on the state. And how did fundamental right came into being? Did I say that yesterday? No. Okay, actually in original, from where the world got to know about the concept of fundamental right? From Bill of Rights. So the very idea of fundamental rights has come from the US Constitution on Bill of Rights. Is there a doubt about that? No. Okay, now you come to Bill of Rights. US Constitution was open for ratification by the states. Okay, so first US war of independence happened, then they made their constitution, and then they opened the constitution to be ratified by various states. Initially there were 13 states, now there are 50 states. So when US constitution was open for ratification by the states, there were two set of scholars. One scholars were called as federalist, other scholars were called as non-federalist. So they started writing articles, and those articles were called as federalist papers, and those articles were called non-federalist papers. Federalists were those people who believed that central government should be very strong. Federal government matlab? Central government. In USA you have Federal Bureau of Investigation. In India you have Central Bureau of Investigation, the central government's investigative body. So federal government should be very strong, and those were the scholars who supported a strong federal government. They started writing article in the support, and they were called federalist papers. And there were some scholars who said if you will make such a strong central government, it will trample upon the rights of the common citizens, and the states would also be subdued before the might of center. So they started writing article in support of only giving bare minimum power to the union government, so that it can maintain the territorial sanctity of the country without actually interfering into the rights of the people. So as a matter of compromise between federalist and non-federalist, constitution amendment was brought in US constitution, and Bill of Rights were added. That okay, let's do one thing. The constitution which has given birth to government, same constitution will give birth to certain Bill of Rights. The government also cannot take away them. If the government wants to amend them, then the Congress will bring an amendment, and it is near to impossible. Why? Because in 220 years, only 27 constitutional amendments have happened in USA. And that too must be ratified by 3 of the states, 3/4, and after ratification, if somebody challenges that, there is a Supreme Court. So fundamental rights in USA were nothing to restrict the power of government, so that the same constitution which is giving birth to citizens, the same constitution, government, the same constitution is giving birth to rights, and those rights cannot be taken away by government, executive branch. They can be amended by the legislature through a special majority, to be ratified by state and to be approved by Supreme Court if challenged. So is it easy to take? So to restrict the powers of the government, to create a society where people would be at the center, and to create an impression that the government will not trample upon the rights of the people, negative obligation was placed on the government. That the government shall not deny equality before law or equal protection of laws. Government shall not, what in India you see, I told you yesterday also, most of the rights you see negative wording. No person shall be deprived of personal liberty or life except procedure established by law. No person shall be denied inequality, it shall be discriminated in public employment on grounds of religion, race, caste, sex, place of birth. No person shall be denied equality before law or equal protection of laws within the territory of India. No person shall be discriminated on the grounds of religion, race, caste, sex, place of birth. No criminal law can be retrospectively applicable. The state shall not award any title except military or academic. Untouchability is abolished. Practice in any form is forbidden. So most of the fundamental rights are positive or negative. The state is actually prohibited from doing something rather than asked to do something. There are some positive rights also. Like the state shall provide free and compulsory education to all children in the age group 6 to 14 in the manner in which state may determine by law. So this is a positive right where state is asked to do something, while other cases the state is prohibited from doing something. So actually fundamental rights are doing nothing, but they are restricting the power of the government, so that the citizens can chill out in peace, and the state must not interfere without any reasonable cause. So getting my point? So you are getting, so fundamental rights, क्योंकि अगर citizens को government बोलेगी ऐसा मत करो, citizens would say you have been established by a constitution, I have been given fundamental rights by the same constitution. You cannot take away fundamental right, only legislature can take away. That too, it will be judicially reviewed if somebody challenges that. So the sanctity of fundamental right is very high. Now why Dr. Sarvepalli Radhakrishnan said that fundamental rights are India's pact with the civilized world? दुनिया को हम भी दिखाएंगे कि हमारे यहां के लोग के पास इतने अधिकार है कि हम एक सिविलाइज सोसाइटी है, सरकार भी उसका कुछ नहीं कर सकती है. Okay, so the point out here is कि the fundamental rights are India's pact with the civilized world. It is a message given out to the world by the founding mothers of India that there will be certain rights which are fundamental in nature, which the constitution is giving to the citizens. Even government cannot take them away. If the government attempts to take, it will be only the parliament, and then too you have the Supreme Court to judicially review them. And they, ordinary law की तो हैसियत ही नहीं है. Ordinary law cannot do anything. If it is touched, it can be touched by a constitutional amendment, and that too will be reviewed by the judiciary. If challenge, of course somebody will challenge, and then so the fundamental rights are restricting the power of a state. And a beautiful statement was given by one of the scholars that which is the best अभी तो आजकल बेस्ट पूछ रही है यूपीएससी. हाँ, बेस्ट. हाँ, बेस्ट तो जो उसके दिमाग में चल रहा है बेस्ट. हाँ, गेटिंग माय, कौन सा कलर मुझे पसंद है, बेस्ट. अभी हाँ जो आप बोले, इट इज लाइक कि चूज, choose the white one, okay, and they will write this, choose the white one, okay, which is in white, okay, so like this, a confusing signal. So the point out, you must have seen that meme, very famous meme, okay, so pata nahi aap log to aliens hai. Anyways, so the point out here is, so this is something which must be understood, that fundamental rights are actually promoting or limiting the power of government. Limiting the power of government, and it is India's pact with the civilized world, because the world is also seen कि government भी हमारे यहाँ powerful नहीं है. Who is powerful? It is the people, and we have a civilized society where the rights cannot be trampled upon. हाँ, अब US की इतना नहीं. You see how politicians speak in USA. You have seen the presidential debate. How they speak in USA. India में कुछ शिष्टाचार अभी बचा है. Okay, so you see they speak anything. Anything. Okay, India may, we have a, actually India and Japan are cultural society, traditional conservatives, what you call in the sense ki traditional societies. So USA is not a traditional society, no? It keeps on changing. We are traditional societies. India and Japan in fact have many commonalities. We both are parliamentary democracies, we both are net importers of energy, we both are traditional societies. So getting, so there are many things. Okay, although Japan is also doing good. Okay, so the point is ki we must understand that fundamental rights are India's pact with the civilized world. They limit the power of government and promote limited government and democracy. Okay, now some rights are positive in nature also, like right to education is a classic example of positive rights. Okay, now comes to the qualified nature of right. Challenges of India and US is same or different? Different. If India you give absolute right, what would happen? So fundamental rights in India are qualified in nature. right है और right के नीचे restrictions है. जैसे fundamental right to freedom of speech and expression. Reasonable restrictions can be imposed on grounds of security of interest, state friendly relation with foreign countries, defamation, contempt. So there are reasonable restrictions. Right to travel throughout the country, it can be restricted in the interest of general public and scheduled tribe. Right to reside and settle, it can be restricted in the interest of general public and scheduled tribe. Right to practice any trade, occupation and profession, the state can prescribe any technical qualification, and state can restrict a particular trade for itself, like atomic energy and space. Railways also used to be there, now they are gradually moving towards, in a way, diluting the government stake in the overall operational thing. Okay, so some routes have also been declared to be privatized. Okay, so that's a different thing. So what is the point out here कि fundamental, so USA का तो मैंने उस दिन बताया था, Texas versus Johnson. A person burned the flag of USA outside the Republican convention. So that person, the case went to US Supreme Court in Texas versus Johnson. US Supreme Court said that burning the flag of USA is freedom of speech and expression. But it is a matter of pain for us why one of our citizen is burning our own flag. In India, you have Protection of Insult to National Honor Act 1971 and Flag Code of India 2002. Flag को कैसे मोड़ना है वो भी दिया हुआ है. Everything is given. Okay, how you will fold that and what will be the diameter and everything. So fundamental rights in USA are relatively more absolute. In India, they are relatively qualified or less absolute. Why? To keep with the pace and the challenges and the what you call aspirations of the country, where you have ample of diversity. To maintain that diversity, you have qualified rights. There, most of the rights, some or the other restriction is there while you are enjoying them. Otherwise, national security and other challenges are there. Such vast populated country with limited resources and diversity still. So it is the beauty of this country that it can survive. Otherwise, USA cannot think of 134 crore population, this diverse. So it is, you are getting my. So same, and you know, when the homogeneity is there, country, there are many challenges are overcome. But there is no homogeneity, there is diversity. Still, we are doing really, really well. So most of the fundamental rights have been made qualified in nature. Some rights, Supreme Court say, are absolute, like right against untouchability. It cannot be practiced in any form, under any circumstances. So getting my point, and SC/ST Prevention of Atrocities Act 1989 and Protection of Civil Rights Act, both of them deal with that. Okay, so all these things are there. So this is basically fundamental rights. Ab ek question hai, fundamental rights are applicable against whom? Most of the cases they are applicable against state. Some cases Supreme Court entertains if it is a reasonable cause against private individuals also, or a company practicing. For example, if your life is taken, somebody murders you, where will you go? Although you will not go, somebody else will go. Somebody attacks you, where will you go? You will go to Supreme Court or nearest police station. Nearest police station. So you'll go there. So actually, nearest Delhi mein to they are very good. Like Delhi police, like you will feel like heaven. Literally, I'm telling you, they will offer you cold coffee. And I once went there and they were like, after 3 months, I got a letter from DCP that what was your experience in police, the police station. So it was like, I was also, and they were inviting for stakeholders comment. So it is very, they will work or not, that is a different thing. But at least they will make you feel good. And about the hinterlands, Ganga Jal movie is the classic example. What about the state of policing in the hinterlands? Okay, so Gandhiji said police is a necessary evil. Gandhiji said this, that police is a necessary evil. We require, because if imagine without police, in this class also I can see the inner instincts. Without police, okay, so they will just break all these things, okay, if they get an opportunity. In school, when you have the last day, how they used to do. So there is an inner instinct to break the law, okay, so that is the thing. But so the point is, so you have to kill that, okay, as soon as possible. Okay, so the point is fundamental rights are qualified or absolute? Qualified. Okay, now they are available against state. If I say go and collect the material from the authority and I leave, so you all will think, who is the authority? I must inform, go and collect the material from counter number 3, Mr. X would be giving. If I say from the authority, then you will go to metro station and ask, who is the authority? Okay, so if fundamental rights are applicable against state, you need to define state. Then only you will be enjoying those rights. So we'll see those things. First we will write philosophical context of fundamental right. Then we'll start with Article 12 after the break. Okay? So we take a break of 7 minutes. I'm saying 7 so that you keep it 10. Okay. 30 minutes. And all these first row people, they come at the last. पीछे वाले बाद में मतलब they come तो disturb नहीं, लेकिन first वाले come तो it's like 10 से 12 minutes we'll have. Okay, let's start. So we have fundamental rights. Now there is a question that what is the meaning of qualified when we used in context with rights? Qualified means certain qualifications have to be fulfilled when you enjoy those rights. Yani they can be restricted. Means you have a fundamental right to freedom of speech and expression. But it doesn't mean that you can say anything. So it can be restricted on the grounds you cannot say something which is against the security of state. You cannot say something that will invite contempt of court against the court. You cannot say something that will lead to 499 IPC, that is defamation. You cannot say something against a friendly country which will deter India's interest. So this means although you have freedom of speech and expression, but actually it is qualified, it is not absolute. Matlab there are certain restrictions, there are certain qualifications when you enjoy those rights, and those qualifications are restrictions. One more thing, this we will of course do, that in fundamental rights you can directly approach Supreme Court under Article 32. This is a very easy thing, but for other rights you cannot go to Supreme Court directly, you can go to High Court under Article 226 of the Constitution. Okay, so this is fundamental rights and other rights. Okay, first you write an introduction, fundamental rights. Fundamental rights, please write. Fundamental rights are provided in Part 3 of the Constitution. Fundamental rights are provided in Part 3 of the Constitution from article fundamental rights are provided in Part 3 of the Constitution from Article 12 to 35. From Article 12 to 35 are provided in Part 3 of the Constitution from Article 12 to 35. Full stop. Then you write, अब ये तो इंट्रोडक्शन एक छोटा सा, प्लीज राइट, राइट्स आर लीगली प्रोटेक्टेड इंटरेस्ट. Rights are legally protected interests. Legally protected interests. Okay. Next you write, अब लिखिए, classification of rights. Classification of rights. Classification of rights. First you write statutory rights. Statutory rights. Statutory rights are those rights which originate from statutory rights are those rights which originate from statutory rights are those rights which originate from an ordinary law or statute, which originate from an ordinary law or statute ठीक है. नेक्स्ट पॉइंट, एग्जाम्पल राइट टू इंफॉर्मेशन एक्ट, महात्मा गांधी नेशनल रूरल एम्प्लॉयमेंट गारंटी एक्ट, राइट टू इंफॉर्मेशन एक्ट, महात्मा गांधी नेशनल रूरल एम्प्लॉयमेंट गारंटी एक्ट, मनरेगा, महात्मा गांधी, M for Mahatma Gandhi, Narega, National Rural Employment Guarantee Act. Okay, this is statutory right. Next you write fundamental rights. Next write, first was A, second is B. Fundamental rights, put a dash and write. These are of highest order. These are of highest order. These are of highest order and are called as Magna Carta of the Constitution. Magna Carta of the Constitution. These are of highest order and are called as Magna Carta of the Constitution. Magna Carta की spelling MAGNA, Magna space Carta, CARTA, Magna Carta of the Constitution. Okay. Third point you write, they are given highest sanctity. They are given highest sanctity. S-A-N-C-T-I-T-Y. Sanctity. Okay, they are given highest sanctity. Full stop. Remedy lies directly to Supreme Court under Article 32. Matlab, if it is violated, you can directly go to Supreme Court. Remedy lies directly to Supreme Court under Article 32. Remedy lies directly to Supreme Court under Article 32 or Article 226. Remedy lies directly to Supreme Court under Article 32 or Article 226 provides for remedy in high courts. Provides for remedy in high courts. Next you write C for Calcutta, right? Constitutional rights. A was statutory, B was fundamental, B के बाद आएगा C. Okay? So A was statutory, B was fundamental, C is Calcutta, so C would be constitutional rights. Okay? Put a dash and semicolon and write. Those rights which are outside part 3 but those rights which are outside part 3 but inside the constitution. Those rights which are outside part 3 but inside the constitution. No remedy lies directly to no remedy lies directly in Supreme Court. No remedy lies directly in Supreme Court. You are getting this point? So there is no remedy in Supreme Court directly. Okay. Example. मैंने तो एक एग्जाम्पल दिया राइट टू प्रॉपर्टी, एक एग्जाम्पल यूपीएससी ने भी दिया है. बहुत ही कंट्रोवर्शियल क्वेश्चन पूछा यूपीएससी, आस्क्ड अ वेरी कंट्रोवर्शियल क्वेश्चन इन 2017. फाइनली आफ्टर द श्राद्ध दे गिव आंसर की, एंड व्हाटएवर यूपीएससी सेज इज द फाइनल. राइट टू वोट विच इज अ कॉन्स्टिट्यूशनल राइट अंडर आर्टिकल 326. ये यूपीएससी ने आंसर की दिया है. राइट टू वोट इज अ कॉन्स्टिट्यूशनल राइट. सो राइट इन इंग्लिश एग्जाम्पल, राइट टू वोट, right to property, right to vote, right to property. This is given by UPSC. Okay, then you write human rights are, change the line and write human rights are those inalienable rights, those inalienable rights. Human rights are those inalienable rights. Human rights are those inalienable का मतलब they cannot be separated. They those inalienable यानी alienate आपसे नहीं किया. That inalienable rights that are expected to be. Human rights are those inalienable rights that are expected to be bestowed upon human beings, that are expected to be bestowed, दिया जाना चाहिए, bestow किया जाना चाहिए, B-E-S-T-O-W-E-D, bestowed, B-E-S-T-O-W-E-D. Human rights are those inalienable rights that are bestowed upon human beings, that are bestowed upon human beings by what? By virtue of being born in human family. Please write. By virtue of being born in human family. Okay. So one important statement you can write in your mains answer, that is the preamble of United Nations Declaration of Human Rights. UNHDR बचपन से सुना है, कब आया था? हाँ, कब? 1948 में कब? 10th December 1948. बहुत ही इंपॉर्टेंट डेट है. दैट इज यूनाइटेड नेशंस डिक्लेरेशन ऑफ human rights. What is the difference between UN Charter and UNHDR? What UN Charter came in 1945. UNHDR came in 1948. What is the difference between UN Charter and United Nations Declaration of Human Rights? एक एक करके बोलिए, बताइए. आदर्श, हाँ बोलिए. Okay, it says the principles of UN and human rights. Anybody else would like to contribute to the Bhandara? Huh? It is actually the Constitution of United Nations led to the formation of UNA. UN Charter is that document. What is the most, why UN was created? Because League of Nations failed and Third World War should be avoided. So if somebody asks you, is UN a successful organization? The prime purpose of UN was to avoid Third World War. Is it successful in doing that? Third, violence तो होगा ही, जब तक ईगो है तब तक वायलेंस होगा, उसमें कोई डाउट नहीं. लेकिन इट हैज पार्शियली अवॉइडेड, पार्शियली क्या, इट हैज अवॉइडेड अ थर्ड वर्ल्ड वॉर. पार्शियली हुई क्या थर्ड वर्ल्ड वॉर? 1 September 1939 सेकेंड वर्ल्ड वॉर, हिटलर अटैक्ड पोलैंड. Hitler crushed France, United Kingdom like anything. But suddenly some बुद्धि, जब समय बुरा होता है तो बुद्धि मारी जाती है. It was fighting a war on the front, western front, crushing United Kingdom, what you call France, चटनी बना दिया. But on 22nd June 1941 Hitler attacked Russia on eastern front. अब ईस्ट से भी और वेस्ट से भी. और जापान 7 दिसंबर 1941 जापान अटैक्ड यूएस. तो जो भंडारे में नहीं आए थे वो भी आ गए. एंड देन यू हैव ऑल यूनाइटेड किंगडम, फ्रांस, रशिया, यूनाइटेड स्टेट्स ऑफ अमेरिका, ऑल अगेंस्ट जर्मनी, इटली एंड जापान. जापान 6th and 8th August bomb dropped. Italy, Mussolini, you know how he was killed. And 30th April 1945, it is supposed that Hitler committed suicide. So Germany, Japan and Italy. So it is the allied powers, that is United Kingdom, France, United States of America, Russia versus the Axis powers, that is Rome, Berlin and Tokyo. Germany, Italy and Japan. So Hitler was initially had a pact with Russia कि इसको चुरने देते, आप भी बीच में नहीं आइए. They had a secret pact which came open later in 1938 that I'll be attacking France and UK. You chill out in the east. Said okay, no problem. But Hitler thought कि अब इसको लपेट लिए, अब इसको. And then there is a beautiful movie, Enemy at the Gates. You must have seen that movie. हाँ, ठीक है, कोई बात नहीं देखा है तो कहां सिलेबस में भी है, ठीक है. सो दिस इज इट. सो यूनाइटेड नेशंस चार्टर led to the formation of UN. Why? League of Nations. League of Nation का नाम सुना है? करोल बाग में रहता है. हाँ, League of Nation तो सुना होगा भाई. हाँ, क्या League of Nation क्या? After the First World War, League of Nations came into being. So League of Nations failed to contain the Second World War. So United Nations was actually formed. So UN was a result of the failure of League of Nations. And see what happened. When India defeated Pakistan, 90,000 POWs were there, prisoners of war. 90,000. So we convincingly defeated them, 90,000. So, but Mrs. Indira Gandhi went and signed Shimla Agreement on 2nd July 1972 when we were having serious edge. Why? Because she learned from history that Germans were treated badly in Treaty of Versailles. They were brought with a folded hand. That led to the rise of Hitler and Second World War. They could not forget the treatment When they lost, they were treated very like inhuman. In the conference, they were made to stand. They were folded hand. This, they were treated in the conference. That led to the signing of Treaty of Versailles. So when India had an upper hand with Pakistan, we had 90,000 prisoners of war. Okay, आंखी बेच देते तो करोड़ों आ जाता. Just kidding, don't think that. Okay, so still we showed magnanimity, and we went ahead. And one of the soldiers, this is on record, said that when General Manekshaw came, he started crying. That our army officers don't take care of us the way you take care of us, providing mosquito nets, food on time, and other sanitation facilities. So we treated them with uttermost respect, dignity, the way prisoners of war are treated, and returned them with dignity. Went ahead when we were having serious edge. We signed Shimla agreement, tried to diffuse the tension, but we were backstabbed. Okay, because we far-sightedness that if we treat them, we are having edge. If we treat them badly, Treaty of Versailles. Germans were treated badly, led to the rise of Adolf Hitler. Okay, so finally, so the point is that this is how international relations work. So UN Charter led to the formation of UNO, and United Nations Declaration of Human Rights actually is, and India has the best of human rights record. In spite of such diversity, most of the time, you know, there may be certain aberrations, but our human rights records are exceptionally well. And we have contributed exceptionally to the UN peacekeeping force. Which are the top 3 countries in UN peacekeeping force? Top 2, India and Bangladesh. Top contributor to UN peacekeeping force. Okay. And top fundraiser is United States. Okay. So they give money, we send more people, trained personnel, and definitely. Okay. So write, so what was that? You write preamble to the United Nations Declaration of Human Rights. Preamble to the United Nations Declaration of Human Rights states that Preamble to the United Nations Declaration of Human Rights states that recognition of inherent dignity, Preamble to the United Nations Declaration of Human Rights states that recognition of inherent dignity and of equal and inalienable rights, recognition of inherent dignity, Preamble to the United Nations Declaration of Human Rights states that recognition of inherent dignity and of equal and inalienable rights, I and inalienable rights, of members of human family, recognition of inherent dignity and equal and inalienable rights of members of human family is the foundation of freedom, justice and peace in the world, is the foundation of freedom, justice and peace in the world. Justice and peace in the world. Okay, so if you write an answer, you will talk about fundamentals. Now you write about Dr. Sarvapalli Radhakrishnan. Make that statement on the paper. Please write. Justice and peace in the world. Dr. Sarvapalli Radhakrishnan, Dr. S. Radhakrishnan stated that, fundamental rights are India's pact with the civilized world. Fundamental rights are India's pact with the civilized world. ठीक है? Fundamental rights are India's pact with the civilized world. ठीक है? आगे लिखिए. Can we say that fundamental rights promote constitutionalism? What is constitutionalism? Limited government. Now somebody from the back bench, Okay, can you please tell me that how do you think fundamental rights promote limited government? How fundamental rights promote limited government? So how it puts restriction, what's your name? आदित्य बताइए कैसे restriction होता है? So she says that Article 13 Clause 1 talks about pre-constitutional laws, Article 13 Clause 2 talks about post-constitutional laws, and the state cannot make a law that takes away fundamental rights. Okay, so this is one restriction on this promotes constitutionalism. So she has answered one point. Anybody would like to contribute and answer? Why do you think that fundamental rights promote constitutionalism? किसी और व्यक्ति को इसमें कुछ बुंदिया जैसे भंडारे में कचौड़ी सब्जी बुंदिया किसी को देना है? हाँ, व्हाट्स योर नेम? जी आदित्य. ओके आदित्य बताइए. ओके, द स्टेट शैल नॉट डिस्क्रिमिनेट ऑन द बेसिस ऑफ रिलीजन, रेस. RRCSP कोड है, रिलीजन, रेस, कास्ट, सेक्स, प्लेस ऑफ बर्थ. निमोनिक्स ऑल इज वेल बहुत काम आने वाला है भैया. Mnemonics, you must learn the art of mnemonics for mains. Mnemonics. Okay. These are guaranteed and protected by the constitution. And what did you say, Aditya? State shall not discriminate on the basis of religion, race, caste, sex, place of birth. Article. So, इससे क्या हो रहा है? State के powers restrict हो रहे हैं या बढ़ रहे हैं? बताइए. Restrict हो रहे हैं. Very good. So all of them have answered correctly that this is the way in which fundamental rights actually promote a limited government or unlimited government. Limited government. ठीक है? So fundamental. So what was the last statement you wrote after Sarpalli Radhakrishnan? Nothing. Huh? Huh? This is statement only. So you have written this is statement only. I'm just kidding. Please write fundamental rights. Fundamental rights are mostly restrictions on the state, are mostly restrictions on the state. Though there are restrictions on the state, though there are positive rights like, बताइए एक positive right बताइए आप. You the one who is wearing white, you're wearing that white handkerchief next to you. You answer me a positive right. You are understanding that I'm asking to you only. So what is a positive right? Okay, what is a positive right? जी बताइए. अच्छा आप तक. So positive. अच्छा, I'll say, you just say yes that the state shall not deny equality before law or equal protection of laws. Is it a positive right or not? Yes or no? Huh? No or yes? Just raise your hand. Is it yes? Acha, if I'll say that the state shall provide free and compulsory education to the children in the age group 6 to 14 in the manner as state may determine by law. Is it a positive right? Yes. Very good. So please write. What did you write last? Like right to education. Education आपको क्या लगता है? पावरफुल चीज है कि कैसे पावरफुल है मैं बताता हूं. देयर इज अ रिच मैन, ही इज ट्रैवलिंग इन लैम्बोर्गिनी और बेंटले और पोर्श और नैनो. ठीक है, एनी कार ही इज ट्रैवलिंग, ही सीज अ साइन बोर्ड और ही रिसीव्स अ व्हाट्सएप मैसेज. सो ही विल आस्क द पर्सन नेक्स्ट टू हिम कि भाई थोड़ा बताना. सो दिस इज इम्पेयरमेंट. This is actually impairment. You see, in spite of having wealth in the city, he will feel himself as not understanding anything left out. So that is education. And there is a difference between knowledge and information. This Albert Einstein has said. Information is not knowledge. Information is fact. what you derive from that actually is knowledge. So right to education, Indira Gandhi said, it is written on the prospectus of IGNOU that education is a liberating force. Education is a liberating force. It is in which list? चलिए आपका क्या नाम है? Green shirt. Yes, what's your name? G? Rajat, what education is in which list? It was in state list, but through 42nd constitutional amendment, Rajat, it has been transferred to concurrent list now, along with sisters, wildlife, forest and weights and measures, कुछ और को भी state list से उठाकर concurrent list में. So if a subject is lifted from state list to concurrent list, state की power बढ़ी या घटी? बढ़ी या घटी? State से छीनकर concurrent में डाल दिया. It is increasing or decreasing? Okay, online they are एकदम silent हैं. हाँ? So now we'll take few questions, please. This is something very rare. So preamble has no legal effect independently of other parts. Please maintain silence. This question actually was asked by one of the student yesterday post class also. Preamble has no legal effect independently of other parts. कहने का मतलब ये है, if socialist term is mentioned in preamble, so by virtue of its mentioning in preamble कुछ नहीं होगा. The idea of socialism is in DPSP, then socialism happens to be. Because preamble has no justiciability. If the term liberty is mentioned in the preamble, it is of no legal effect. The ideas of liberty in fundamental rights promote legal effect. So this is statement that preamble has no legal effect independently of other parts. So whatever is mentioned in the preamble which be enforceable only if the same is mentioned in other parts. So if the term socialist is mentioned in preamble, it will be applicable if the idea is there in directive principles. Just by writing in preamble is just like बोल देना कि birthday है मेरा आ जाना, ना date बताया, actually not inviting. You are getting my point, na? So it must have, so if you forward the message with the date, venue, okay. Getting my point, sir, that is something. Okay, then one question is, how does Article 3 promotes federalism? This we'll see later. Otherwise, federalism, we will inter-Pacific Ocean with no compass. Okay, so I'll not go to that. Okay, what is quasi-federal? Partially federal, in simple terms. Okay, or quasi-federal or sui generis federal with unitary bias, we will see. One question which Aditya Sharma has asked, that simple majority and special majority. So this is something which actually I was thinking that I should do now or I should do later. Okay, because now when we will be doing how the laws are passed in Parliament, Article 111, then we will do. If I feel like, we'll do. Because here brutal confusion is there. All the majorities look very simple, but they are not. Okay, so now we'll continue with fundamental rights, then we will do majorities. Okay, it is a separate topic, but we can do any time. So first you write Article 12, definition of state. Article 12, definition of state. Article 12, HEADING, heading, definition of state. सब कुछ खुद करना है भाई, मैं नहीं रहूंगा एग्जामिनेशन हॉल में कि विद इन फ्यू मिनट्स अच्छा 17 क्वेश्चन जल्दी से मार दो और फिर दूसरे बच्चों को देखने कोई कन्याकुमारी से एग्जाम दे रहा होगा. So for me everybody is equal. So you must learn how to do things by your own. Atmanirbhar Bharat. Okay, so we will come to your question, Aditya, don't worry. Okay, so we have Article 12, that is definition of state. Now, first of all, fundamental rights are mostly applicable against state. इस line को समझिए. If you are assaulted by an individual, where will you go? You will go to the police station. If the police is not registering FIR, you will go to the court. So if your fundamental right to life is assaulted by another person, you do not go to Supreme Court in simple causes. There are some cases where habeas corpus is allowed against private individuals also. Rarest case. I'll give you those cases also. Chandrima Das, then Najib case. There are few cases. Anyways, leave that. Otherwise, if fundamental rights are violated by an individual, you will go to Police station you will not go to. So most of the fundamental rights are applicable against whom? Now you understand how it works. There is a right to equality. ठीक है? Article 14 कहता है there is a right to equality. Kerala government passes a rule that women in the age group 10 to 50 cannot enter Sabrimala temple complex inside the Pathanamthitta district in near Periyar Tiger Reserve. Lord Ayappa is there and he practices celibacy. He may get distorted. So women in the age group 10 to 50 cannot enter Sabrimala temple complex. Okay, and this is provided in a rule framed by the Kerala government under Kerala Temple Authorization of Entry Act. उस एक्ट के तहत एक रूल बनाया जिसमें विमेन को इंटर करने से रोक दिया. So this is violative of Article 14. So who violated your 14? A woman in the age group 10 to 50 is not allowed. Other women are allowed. Males are allowed. So violation of Article 14. So किसने violate किया? Kerala government by passing such order through a law. It was an Kerala Temple Authorization of Entry rules through Kerala Temple Authorization of Entry Act. So Act के तहत rule बनाया rule. So this rule actually is passed by whom? Made by whom? Kerala government. So who is violating the fundamental right in this case? The state government. Next point. We have a freedom of speech and expression. Okay. Now the Parliament of India passes a law, Information Technology Act 2000. In which year? 2000? Okay. Section 66 capital letter A. Section 66 capital letter A of Information Technology Act empowers the police to file an FIR if you create disturbance or annoyance over internet. अगर आप डिस्टर्ब कर रहे हैं और अनॉय कर रहे हैं तो आपके खिलाफ एफआईआर दर्ज हो सकती है. अ केस कैन बी रजिस्टर्ड अगेंस्ट यू. हु पास दिस लॉ? Information Technology Act 2000 passed by Parliament. Who passed this law? Parliament passed this law. Okay. So this law is an ordinary law. ये ordinary law है, but fundamental right article 19(1)(a) says you have a freedom of speech and expression. It can be restricted, but on reasonable grounds, not on unreasonable ground. Annoyance, disturbance, ये जो term use हुआ है act में, annoyance और disturbance, don't you think this is a very general term? Anybody can, if you put this what you call chair from here to here, there can be annoyance and disturbance. So a very general term is used empowering the police to restrict your freedom of speech and expression. A politician died. A lady from Maharashtra, Mumbai, she wrote a post on Facebook that why the city is closed for 3 days. Anybody who wants to mourn the death, he should be allowed to mourn and other people should be allowed to do their thing. Another friend of her liked the post. Okay, both of them were arrested under IT Act 2000 Section 66A because they created annoyance and disturbance. So IT Act Section 66A is violative of Article 19(1)(a). And if there is a clash between Constitution and ordinary law, which will prevail? Constitution. तो Supreme Court ने श्रेया सिंघल वर्सेस यूनियन ऑफ इंडिया केस में Section 66A of IT Act को अनकॉन्स्टिट्यूशनल, null and void घोषित करके खत्म कर दिया. So null and void it was declared. So who violated the fundamental right this time? This was who violated the fundamental right by enacting Section 66A? It was the Parliament which makes the law and actually it violated fundamental right. So if your fundamental rights are violated by executive or the district magistrate passes an order that anybody who wears white shirt on Monday will actually be imprisoned. So actually this order is violating your right to life. So who is violating? The executive. In all these cases you will go to Supreme Court. That is Article 32 or High Court under Article. But at the same time, if I am not allowing, if I am what you call, have a private sports complex or if I have a private sports area inside my house, I will allow only certain people and I will not allow others. So it is my choice. I can allow, I cannot allow. So here you cannot claim violation of fundamental rights. So in 90% of the cases, 95% of the cases, when you will go to Supreme Court, when fundamental rights are violated by the state, executive or Legislature. So you have to define what is executive and what is legislature. I will say that go and collect the material from the authority. Who is the authority? I must standardize ki gate number 12, desk number 13, Mr. Vijay Kumar will be sitting, he will give you the material. So if fundamental rights are applicable against the state, it is extremely pertinent and important to define state. कहने से तो नहीं होगा कि स्टेट सुना था ऐसा है, कीनू थोड़ी है. हाँ, that parody account of that ये orange you have seen in Delhi. Okay, pata nahi, you all have landed from Mars, so that's a different thing. Okay, so the point here is कि fundamental rights are applicable against the state, so you have to define state. So that definition is given in Article 12. फर्स्ट पॉइंट समझ रहे हैं ना. अगर आपको फंडामेंटल राइट किसके खिलाफ एप्लीकेबल है, स्टेट के खिलाफ, तो ये बताना जरूरी है कि स्टेट किस चिड़िया का नाम है. उसी का नाम दिया हुआ है आर्टिकल 12 में. नाउ यू टेल मी, नाउ डेफिनेशन ऑफ स्टेट इन आर्टिकल 12 इज अ जनरल डेफिनेशन और ओनली फॉर फंडामेंटल राइट्स. व्हाट्स योर नेम? यू, या यू ओनली. नहीं नहीं, आपके बगल में. यस, नेक्स्ट टू यू. व्हाट्स योर नेम? जी, साई. ओके, वंडरफुल नेम. साई, प्लीज टेल मी दैट do you think that the definition of state in Article 12 is applicable only for fundamental rights or general? Because it is, Article 12 is dealing with fundamental rights, so the definition of state in part 12 is only for fundamental rights. Yani whatever is the definition of state, if these organizations violate your fundamental right, you can go to Supreme Court. If other organizations violate your fundamental right, go to police station, do not go to Supreme Court, because fundamental rights in most of the cases, there are some exceptions, I'll come to that, are applicable only against state. So do we need to define state? Yes. और directive principle में ज्यादा झोल नहीं लिया है. They have not taken much tension. In Article 36, Article 36 is directive principle starts from 36 to 51. What's your name? जी, आपका नाम? Divya. Divya, fundamental rights are from which article to which article? 12 to 35. Very good. So directive principles are from 36 to 51. So for directive principles also you need to define state. So they have not taken much tension. They have written in Article 36 that the definition of state and fundamental right shall be same as that of directive principle. यानी जो भी definition state का part 3 में वही applicable होगा part 4. The same definition will be, it is written in Article 36 that the definition of state in part 3 shall be applicable in part 4. You are getting this? So Article 12 defines state. State for the sake of state or for the sake of fundamental rights? For the sake of, only for the sake of, I will add the term only for the sake of fundamental rights. So what is Article 12? अब इसमें कह रहा है यूनियन गवर्नमेंट, यूनियन पार्लियामेंट. Okay, state government, I am making it very lucid for you. State government, state legislature. Okay, local authorities. So you have PRIs and ULBs, Panchayati Raj institutions and urban local bodies. उसके बाद एक खतरनाक टर्म है, इसको लेके सुप्रीम कोर्ट सो यूनियन गवर्नमेंट, पार्लियामेंट, कोई कंफ्यूजन है? नहीं है. स्टेट गवर्नमेंट, स्टेट लेजिस्लेचर, कोई कंफ्यूजन है? नहीं है. लोकल अथॉरिटीज, नो प्रॉब्लम, पीआरआईज एंड, अब लिख दिया अदर अथॉरिटीज. सो वेदर इट विल बी एप्लीकेबल अदर अथॉरिटीज. अब सुप्रीम कोर्ट ने जस्टिस पीएन भगवती इन वन ऑफ द मोस्ट लैंडमार्क केसेस, दैट इज आरडी शेट्टी केस. In R.D. Shetty case, Justice P.N. Bhagwati laid down 5 guidelines. अगर इन पांचों में से कोई भी एक होता है, so it will also qualify as state for the sake of fundamental rights. So other authorities को डिफाइन करने के लिए सुप्रीम कोर्ट ने कुछ गाइडलाइन दे दी कि अगर ऐसा पाया जाता है तो वो भी स्टेट बन जाएगा और उसके खिलाफ भी फंडामेंटल राइट लागू हो जाएगी. So to qualify as state, certain basic guidelines are given SAI, and these guidelines would be actually followed to determine whether it is a state or not. And you know, every judgment of Supreme Court is having validity as that of law. Article 141 of the Constitution, judgment of Supreme Court is law. It is actually a law. So the sanctity is very high. So what are the basic criteria that Supreme Court has given to determine whether it is a state? Whether that organization is substantially financed by the government or not. यानी उसका ज्यादा खर्चा सरकार दे रही है. Second, whether that agency is working as an instrument of state or not. हो सकता है प्राइवेट एंटिटी है, पर इट इज वर्किंग. फॉर एग्जांपल टीसीएस इज वर्किंग इन मिनिस्ट्री ऑफ एक्सटर्नल अफेयर्स और पासपोर्ट सेवा. Infosys is working as central processing center of income tax department. So they are working as an agency of state. Third, whether they enjoy the monopoly status. अब ये थोड़ा आराम से समझते हैं. For example, government tomorrow says that only Bata will be making shoes. No other company has been given permission to make shoes other than Bata. Because Article 19(1)(g Constitution में कहता है, 19(1)(g, state can restrict any trade partially or fully for itself. If the state wants, entire trade will be restricted only for itself. Nobody else can trade that. This is given in the Constitution. Tomorrow the state says that only Bata shall be manufacturing shoes. So Bata will enjoy monopoly. Monopoly होगी ना बाटा की. So third point, Justice Bhagwati says any organization enjoying monopoly. Next point he says, if a government department is converted into a corporation, जैसे Delhi Transport Department may be converted into Transport Corporation. Corporation में थोड़ा legitimacy, autonomy थोड़े रहती है. So this is. So and to what extent the government can appoint or remove its head. So broadly, these are the qualifications paradigm in which it will be qualified whether it is a state or not. Now comes an important point. Reservation is provided in government jobs. It is also provided in LIC. It is also provided in SBI. It is also provided in IBPS. So these are the organizations where majority stake is held by the government and they qualify as state under Article 12 of the Constitution because they are substantially financed by the state. They are working as an instrument of the state. Appointment is made. एक criteria fulfill हो तो काफी है. One criteria. But here there are multiple criteria are fulfilled. So all these public sector banks, public sector undertakings qualify as state under Article 12 of the Constitution. So what is Article 12? Although they usually in the class always they start with Article 14. They teach Article 14, never 12 is discussed. But what about UPSC, Unpredictable Public Service Commission? So they can ask, normally this 12, this is normally basically taught in judiciary classes. I used to take Constitution for them. So then it is 12, but 12 is nothing but the definition of state for the, not half complete statement hai. Definition of state for the sake of fundamental rights only. And the same has been extended to DPSP by Article 36 of the Constitution. So please write Article 12, definition of state. Article 12, definition of state. Fundamental rights are mostly available. Fundamental rights are mostly available against the state. Fundamental rights are mostly available against the state. Therefore, it is imperative, fundamental rights are mostly available against the state. Therefore, it is imperative to define fundamental rights are mostly available against the state. Therefore, it is imperative to define state. Imperative matlab important. Imperative matlab important. समझ रहे हैं? Therefore, it is Aditya, you are getting it? It is important to define state for the sake of fundamental rights. Please write for the sake of fundamental rights. Article 12 states that state includes, Article 12 states that स्टेट इंक्लूड्स, क्या लिखवाना चाहिए? पार्लियामेंट कॉमा गवर्नमेंट ऑफ इंडिया, पार्लियामेंट कॉमा गवर्नमेंट ऑफ इंडिया, पार्लियामेंट कॉमा गवर्नमेंट ऑफ इंडिया। आप बताइए क्या आगे क्या लिखवाना चाहिए? अलाउ क्या, व्हाट्स योर नेम? प्रशांत, ओके प्रशांत, प्रशांत, प्रशांत इज योर नेम, ओके प्रशांत। पार्लियामेंट गवर्नमेंट ऑफ इंडिया, नेक्स्ट। बट अलाउ, प्लीज अलाउ हिम टू स्पीक। स्टेट क्या? स्टेट, स्टेट लेजिस्लेचर एंड स्टेट गवर्नमेंट। जैसे यूनियन पार्लियामेंट और यूनियन गवर्नमेंट है, उसी तरह स्टेट लेजिस्लेचर और स्टेट गवर्नमेंट। प्लीज राइट स्टेट लेजिस्लेचर, स्टेट गवर्नमेंट। Online warriors are silent. So state legislature and state government. Okay. Then you have other authorities. Yeah, local authorities. Local authorities and local authorities and other authorities. Local authorities and other authorities. Okay. Now you write the Supreme Court. The Supreme Court. So what did we write? Union government, parliament, state government, state legislature, local authorities and other authorities. कोई doubt है इसमें? Now you write the Supreme Court in R.D. Shetty case. R.D. Shetty case. There are other cases also, but this is an important one. The Supreme Court in R.D. Shetty case gave certain tests. Gave certain tests. Gave certain tests to determine whether an organization qualifies as state or not. Whether an organization qualifies as state or not. ठीक है? Full stop. The factors are whether financed by state or not, whether financed by state or not, whether financed by state or not, comma, किस हद तक स्टेट कंट्रोल करता है, अपॉइंटमेंट एंड ऑल दीज थिंग्स, टू व्हाट एक्सटेंट इट कंट्रोल्स। पहले तो वेदर फाइनेंस बाय स्टेट और नॉट, एलआईसी को किसने एस्टैब्लिश किया? हु एस्टैब्लिश? गवर्नमेंट। सो कैपिटल इन्फ्यूजन किसने किया होगा? गवर्नमेंट इन्फ्यूज द कैपिटल, सो फाइनेंस बाय होम? गवर्नमेंट, कॉमा, अब कह रहा है डीप एंड परवेसिव कंट्रोल ऑफ स्टेट, गवर्नमेंट। सो क्या उस पे गवर्नमेंट, हु अपॉइंट्स द डायरेक्टर ऑफ पंजाब नेशनल बैंक? Government. Why? Because government is the owner of majority of the stake. So government, Banks Board Bureau makes recommendations. On the recommendation made by BBB, actually appointments are made. Who appoints the director of ONGC? Government. Because who is the owner of ONGC? Government. Till the time government has a majority stake, it will. So second comma deke, deep and pervasive control of government. Deep and pervasive control of government. Control of government, comma, whether functions are public or private in character, whether functions are public or private in character, जो ऑर्गेनाइजेशन काम कर रहा है वो पब्लिक फंक्शन है या प्राइवेट इन कैरेक्टर, whether the function is public or private in character, whether the agency is enjoying monopoly status, whether the agency is enjoying monopoly status, or whether the agency is enjoying monopoly status और बताइए क्या होना चाहिए, क्या वो उसमें डीप एंड परवेसिव कंट्रोल आया, वेदर व्हाट appointments, deep and pervasive control, appointment also, reservation. Oh, so reservation तो उसका once state then reservation, not reservation then state. Controlled by deep and pervasive control we have already written. हाँ किसी ने बोला, आदित्य आपने बोला, किसने बोला, हाँ somebody said the right answer, I heard. Sorry, working as an agency, so chalo it is deep and pervasive. Something more when I gave an example also. Works for the, so agency public in character. TCS is providing passport, matlab seva. So actually it has a public role that is covered. Whether the government department is converted into a corporation, please write, or government department converted into a corporation. Okay. Somebody has mailed me the latest version. Okay. दिल पे नहीं लेना है भाई, बाकी तो मुझे याद ही है, लेकिन आपको दिखा देता हूं. दिल पे बिल्कुल नहीं लेना है, क्वालिफाई करने का. यू हैव टू बी सिंसियर और सीरियस. सिंसियर और सीरियस दोनों नहीं होना है. सीरियस दिखना नहीं है माहौल बनाने के लिए, रिश्तेदारों को बाल बड़ा कर लिया. If possible, never inform them. If never ever inform them. Never inform anybody. Never ever seek recognition before selection. Getting my point? उससे पूरा नुकसान ही नुकसान है, फायदा कुछ नहीं. ख्याली पुलाव कब तक बनेगा? तो इसीलिए पुलाव असली बनाइए. हाँ, never inform any relatives that you are preparing or any such thing. What you are doing? Started tikki chola at Old Rajendra Nagar. Okay, so we have Article 12. हाँ, क्या? It says never inform your relatives, otherwise they will ask every year. हो तो नहीं गया? So it says in this part, unless the context otherwise requires, the state includes government and Parliament of India, government of India and Parliament of India, government and legislature of each of the states, local or other authorities within the territory of India are under the control. So this other authorities has been defined by Supreme Court. Now we have 1 hour, so we'll be doing with Article 13. So, okay, so it is all laws. Now it says this is Article 13. Actually, from a scholar perspective, Article 12 and 13 is very important. From a scholar perspective, क्योंकि Article 12 पे किताबें लिखी जाती हैं. Definition of state. Recently, a book has come which Mr. Faizan Mustafa was actually recommending. He's the Vice Chancellor of Nalsar University. So it's a very intellectually provoking. That is Article 12. पर UPSC को तो ये सब नहीं चाहिए ना कि किताब लिख दे 12 पे और ओल्ड राजेंद्र नगर में एकदम ट्रीटी ऑफ वेस्टफीलिया पे आधा घंटा भाषण दिया. आई हर्ड somebody said to a चाय वाला that you don't know I've written mains. Yeah. Literally, a friend of mine said that someone got into an argument and he said to the chai wala, don't underestimate the common of a mains aspirant. The power of a mains aspirant. Okay. So, anyways, so you have all laws in force in the territory of India and immediately, and these people have made aspirants. उसमें सबसे घटिया रोल लेकिन टीचर को दे दिया है. They have not done justice. Anyway, so it is all laws in force in the territory of India immediately before the commencement of this constitution. Now please see this. Okay. Now it is Article 13. Okay. Article 13 is the most debatable article till Keshwananda Bharti judgment. The term law in Article 13 is the most debatable. जितने केसेस आपने सुने हैं, सज्जन प्रसाद, शंकरी प्रसाद, सज्जन सिंह, गोलकनाथ, केशवानंद भारती, all are revolving about the term law in Article 13. So today we will only understand the term law in Article 13. That is very, very important. In UPSC also they can ask a general question. Okay? तो अभी एक नया पेज खोलते हैं, ठीक है? Law. Now just be very attentive. Okay, it says, I am just rephrasing the constitution for your convenience. No law can take away. This is a very conceptual thing. पूरे के पूरे केशवानंदा भारती से पहले जितने केसेस हुए हैं, all the cases before Keshwananda Bharti were revolving around the term law in Article 13. Then we'll see article. Once you understand this, then it is halwa. Okay. So you have no law can take away fundamental rights. Okay. Now I will ask few students. You first read this statement. Okay. No law can take away fundamental rights. They are not writing anything close hai kya? Okay. So no law can take away fundamental rights. Okay. Now you answer me. Article 13 says that कोई भी law fundamental right को ले नहीं सकता. We'll see. Can take away, abridge. Abridge means I'm standing here, somebody is standing there. There is a bridge that is connecting us. If you remove that bridge, the distance will be abridged. Yani we will no longer be connected. So bridge versus abridge. Okay, getting my point. Now it says no law can take away fundamental rights. So if the term law means ordinary law, okay, this is a conceptual question I will ask. आर्टिकल 13 सिर्फ कहता है कोई लॉ फंडामेंटल राइट्स को ले नहीं सकता है, छीन नहीं सकता है, कुछ नहीं कर सकता, कैन नॉट टेक अवे, इट कैन नॉट अब्रिज. नाउ द टर्म लॉ इज, इफ द टर्म लॉ इन आर्टिकल 13 मींस ऑर्डिनरी लॉ. व्हाट इज योर नेम? जी अनुराग जी, ठीक है. अनुराग आप मुझे बताइए कि इफ द टर्म लॉ मींस ऑर्डिनरी लॉ, कैन कॉन्स्टिट्यूशन अमेंडमेंट बी टेक अवे फंडामेंटल राइट्स? आराम से सोचिए, सिर्फ सोचना और कुछ नहीं करना है. कहता है कोई भी लॉ फंडामेंटल राइट नहीं ले सकता है. नो लॉ कैन टेक अवे फंडामेंटल राइट. इफ द मीनिंग ऑफ टर्म लॉ इन आर्टिकल 13 इज ऑर्डिनरी लॉ, तो क्या कॉन्स्टिट्यूशन अमेंडमेंट फंडामेंटल राइट्स ले सकता है? Again listen to me. nahi, you are not listening. That is why it says no law can take away fundamental right, and the meaning of term law in article 13 is ordinary law only. The meaning of term law is ordinary law only. Can constitution amendment take away fundamental rights? Yeah. How many say yes? इधर उधर मत देखिए, अपना सोचिए. हाँ ठीक है, देखो एक बार अच्छे से उठाइए, मैं देखना चाहता हूं. ओके, हाउ मेनी से नो? ओके, बाकी कुछ से ही नहीं. दे विल आस्क इन पर्सनालिटीज, व्हाट इज योर ओपिनियन अबाउट नक्सलिज्म? हाँ कुछ तो बोलिएगा. हाँ अरे सर शर्म आ रही है क्या, आप ही बता दीजिए. सो ऐसा तो कुछ. हाँ सुनिए, it says that no law can take away fundamental right. If the term law in article 13 means ordinary law, then only ordinary law cannot take away fundamental right. Constitutional amendment can take away fundamental right. You are getting my point? So if the term law in article 13 means ordinary law, then ordinary law cannot take away fundamental right, but constitutional amendment can take away fundamental right. So if the term law in article 13 includes constitution amendment and ordinary law both, then both constitution amendment and ordinary law cannot take away fundamental right. So if the Supreme Court is ruling, किसी को नहीं समझ में आ रहा है प्लीज हाथ उठा दीजिए. अगर सुप्रीम, फर्स्ट आई विल स्पीक इन हिंदी, बहुत इंपॉर्टेंट है ये. अगर सुप्रीम कोर्ट ये रूल करती है, देन आई विल स्पीक इन इंग्लिश. अगर सुप्रीम कोर्ट ये रूल करती है कि टर्म लॉ जो है आर्टिकल 13 में, उसका मतलब कॉन्स्टिट्यूशन अमेंडमेंट भी है और ऑर्डिनरी लॉ भी है, तो इससे पार्लियामेंट की पावर घटेगी कि बढ़ेगी? कॉन्स्टिट्यूशन अमेंडमेंट भी है तो घटेगी क्या बढ़ेगी? हाँ, यानी So I am repeating in English, if the Supreme Court rules that the term law in Article 13 includes ordinary law also and constitution amendment also, so the parliament cannot take away fundamental right by ordinary also and also by constitution amendment. So the restricted definition of law in Article 13 actually empowers the parliament, and the broad definition of Article 13 actually restricts the right of parliament. Constitution कहता है कि law cannot take away fundamental rights. So if the term law का मतलब ordinary law है, so only ordinary law cannot take away fundamental right. Constitution amendment can take away fundamental right, but ordinary law cannot take away fundamental. You are getting it? Understanding? So the term law का interpretation के लिए पूरा दही जितने भी cases हैं सब इसी पर है. What is the meaning of term law in Article 13? Now in 1967 in Golaknath versus State of Punjab, Supreme Court ने कह दिया the term law in Article 13 includes ordinary law and constitution amendment. In 1967, Supreme Court said that the term law in Article 13 includes ordinary law also and constitution amendment also. So ordinary law, no law can take away fundamental right. So no ordinary law cannot take away fundamental right, and constitution amendment also cannot take away fundamental right. So this was a victory of parliament or a restriction of parliament? Brutally, parliament was restricted कि you cannot take away fundamental right even by a constitution amendment. So Golaknath basic structure doctrine, Keshwananda Bharti versus State of Kerala. Now we are coming to that. Okay. So the term law in Article 13 was ruled by Supreme Court in Golaknath versus State of Punjab 1967 judgment that the term law in Article 13 includes both ordinary law also and constitution amendment. So parliament cannot, no ordinary law or no constitution amendment can take away fundamental right. So it actually put a full stop on the power of parliament to amend fundamental right and take away any of the fundamental. It can add a fundamental right, but it cannot take away a fundamental right. आसमान और जमीन का अंतर है. You cannot take away a fundamental right, but you can actually add. So the power of parliament was brutally restricted. So Golaknath versus State of Punjab was in favor of legislature or against legislature? It was against legislature. And contrary to the popular perception, Keshwananda Bharti versus State of Kerala was purely in favor of government. So it was in 1967 when this was ruled in Golaknath versus State of Punjab that the term law in Article 13 means ordinary law also and constitution amendment. So ordinary law cannot take away fundamental right, and constitution amendment also cannot take away fundamental right. So who was the prime minister? On 27th May 1964, Nehru ji died. Immediately Gulzari Lal Nanda ji was made prime minister for a few days. Then Lal Bahadur Shastri came. On 10th 11 January 1966, Mr. Shastri died. Immediately Gulzari Lal Nanda became prime minister for a few days. Then Mrs. Indira Gandhi came, and she was there till 31st October 1984 when she was assassinated. Okay, in between on 23rd March 1977, Morarji Desai became the first non-Congress chief prime minister, and on 14 January 1980 again Mrs. Indira Gandhi came back to power with majority, and she continued till she was assassinated on 31st October 1984. So who was the prime minister from 1966 till 23rd March 1977? It was Mrs. Indira Gandhi. Okay, so she actually brought a constitution amendment in Article 13 and also in Article 368. The power to amend the constitution is unlimited, and the term law in Article 13 does not include constitution amendment to actually circumvent the judgment of Supreme Court in Golaknath versus State of Punjab, to actually change the judgment of Supreme Court in Golaknath versus State of Punjab. These amendments were challenged in Keshwananda Bharti versus State of Kerala. Now this was 1967. Next came 24th April 1973. पहले ये आया या पहले ये आया? 1967, then you have 68, 69, 70, 71, 72, and then 73. Okay, because I get sometimes those questions. So they say, some say कि I am not understanding. भैया प्रॉब्लम आप में है, मैं क्या करूं? मतलब आंखें निकाल दूं? बेसिक तो एक बार खोल के हाथ ऐसे कीजिए, अगेंस्ट द ग्रेविटी बुक को उठाइए, ऐसे रखिए, एक बार देखिए, देन यू विल अंडरस्टैंड. यू जस्ट थिंक यू कम एंड विजन आईएएस लैब विल प्रोवाइड अ पॉलिटी कैप्सूल. फंडामेंटल राइट बेटा, जाते जाते यूनियन टेरिटरीज भी ले लो. तो वो भी ले लिया, खत्म. एंड देन मीन्स करंट अफेयर्स की कैप्सूल जैसे जैसे मंथली आएगा बनेंगे. सो यू हैव टू वर्क, नोबडी कैन वर्क ऑन योर बिहाफ. थोड़ा नो वेयर यू विल बी लाइक पीपल वुड बी वर्किंग फॉर यू, बट अनडाउटेडली इट इज यू विल, बिकॉज अल्टीमेटली यू विल एंजॉय. Ultimately, you will enjoy and you will be in the field. Okay. So that is something which you have to like, getting my point. So it is 24th April 1973. ये साल पहले आया कि ये साल? ये आया पहले. So after that, this is Keshwananda Bharti. Keshwananda Sripad Gopala Bharti versus, अभी एक मेरे फ्रेंड से, they have asked the question, somebody they have asked the question, what was the date of Keshwananda Bharti in UPPSC interview. So another person who went there, they asked too many factual questions, ekdam factual question. If they like, what is the name of my mama? So you cannot answer that. Okay. So actually he every time he said, no sir, I don't know. I'm sorry sir, please, sorry. And actually he got some single digit rank only. He got into IS also. And then in Hindi newspaper they published a story कि जिसको खोज रहे थे यूपी वाले वो पाया गया लबासना में. So this is like a story that they published in Hindi. The one you are like they were looking for in UP found in Mussoorie. Okay. Anyways, so they asked this date actually 24th April. So in Keshwananda Bharti versus State of Kerala. Okay. Supreme Court said 9. Golaknath was wrong. Highest judge bench till date, 13 judge bench, ruled that the term law in Article 13 means ordinary law. It does not mean constitutional amendment. So, no law can take away fundamental right. Only ordinary law cannot take away fundamental right. Constitutional amendment can take away fundamental right. Since this is something which is very interesting, Keshwananda Bharti. So there is a scholar T. Adhyarjun. He actually got 4th rank in civil services, left the job and started practicing and went on to become one of the most renowned lawyers of the country. He has written a book on Keshwananda Bharti. So from 26-25 October se hearing chali till 24th April, what went on every day in the court, minute noted down, and he written a beautiful book. He says in that book that the basic structure doctrine is actually brought in India by one of the person called as Dieter Conrad. So I will dictate, don't worry. He was a German scholar who came to India, addressed a seminar in ILI where he mentioned, and there was a lawyer M.K. Nambiar. He actually mentioned the term basic structure in Golaknath case for the first time. And finally it was ruled by Supreme Court on 24th April. Justice Mudolkar is also given credit, but Mr. T. Adhyarjun gives credit to Dieter Conrad. Many people say that basic structure has been inspired from German constitution. Germany ke constitution mein there are few provisions which cannot be amended by the parliament. Okay. So Supreme Court on 24th April 1973 said that the term law in Article 13 means ordinary law, does not mean constitution amendment. The term law in Article 13 means ordinary law, does not mean constitution amendment. Parliament has unlimited power in the sense that it can amend any part of the constitution. We don't have any problem including that of fundamental right ही को लेकर बहस चल रही है ना कि the term law cannot take away fundamental right. So it says it can amend entire constitution including fundamental rights. So was it a victory for government or defeat for government? Victory. Contrary to the popular perception, Supreme Court actually overturned the judgment of Golaknath in Keshwananda Bharti. And then the Supreme Court said that no problem, you amend any part of the constitution. Only concern we have is that the Constitution of India the Constitution of India, the edifice of the Constitution of India. Edifice का मतलब building. The building of the Constitution of India, the term that we use is edifice. Edifice of the Constitution of India is resting on certain basic pillars, and these are called as basic structure. So you can amend any part of the Constitution. We don't have any problem without amending the basic structure of the Constitution, because if you remove the basic structure, the edifice of the Constitution shall be falling down. Getting my point? So you can amend any part of the Constitution, including that of fundamental rights, but without violating basic structure. Now the next question is the term basic structure defined in Constitution? No. From where the term basic structure has come? From the judgment of Supreme Court in Keshwananda Bharti versus State of Kerala. What is basic structure? First basic structure is supremacy of the Constitution. First you must accept that it is Constitution which is supreme, but not any body, parliament, judiciary or legislature. Second basic structure, independence of judiciary, federalism, secularism, rule of law, democratic character of Indian state, republican form of government. All these things are basic structure. So is the term basic structure defined in the Constitution? No. Is the term basic structure anywhere defined? No. Who gave this theory? Supreme Court, Keshwananda Bharti. Is basic structure theory organic? Yes. पहले सुप्रीम कोर्ट ने कहा सुपरमेसी ऑफ कॉन्स्टिट्यूशन, फिर सुप्रीम कोर्ट ने कहा इंडिपेंडेंस ऑफ जुडिशरी, फिर 11 मार्च 1994 कहा सेक्युलरिज्म, फेडरलिज्म. सो द बेसिक स्ट्रक्चर थ्योरी इज actually expanding. It is organic in nature. Okay, so this is basic structure. Now one important thing, कि the basic structure theory is nowhere in the Constitution. It is given by Supreme Court. On which ground? The judgment of Keshwananda Bharti actually is kept in Supreme Court Museum. I have read the entire judgment. What is the logic they have given in arriving at a conclusion? I told you that every judgment of Supreme Court is divided into two parts. Obiter dicta, that is the observation of the court, and ratio decidendi, that is the binding part of the judgment. 400 पेज में obiter dicta है, कहानी किस्सा ऐसा क्यों हुआ, and 20 पेज में you have ratio decidendi, actually what is the binding part of the judgment. So what is the logic Supreme Court has given to arrive at this conclusion? LOGIC, what is the logic they have given? That is important to understand this case forever. Okay, so Supreme Court says that there is Article 368 gives constituent power. The term is used in the Article 368, constituent power to Parliament to amend the Constitution, and Constituent Assembly, that was from कब से कब तक थी भाई? 9th December 1946 से 26th of November 1949. So Supreme Court very beautifully explains the difference between constituent power of Parliament to amend the Constitution and constituent power of Constituent Assembly to make a Constitution. Supreme Court says Constituent Assembly was a free body. It can make any constitution, but the power to amend the Constitution to the Parliament, the power to amend the Constitution, this is Constitution, and this Constitution under Article 368 is giving power to Parliament to amend itself. So the power to amend the Constitution cannot become greater than the Constitution itself. So the constituent power of Parliament to amend the Constitution is coming from the Constitution itself. So the legitimacy of Constitution cannot be exceeded by the Parliament, so it cannot overstep the boundaries of the Parliament, and it gave a strong definition that the constituent power of Parliament to amend the Constitution is brutally different from the constituent power of Constituent Assembly to make a Constitution. Constituent Assembly can make any Constitution it like, but Parliament can derive the power from Constitution. It cannot overstep the boundaries of the Constitution, and therefore the Parliament can amend any part of the constitution. We don't have any problem without violating the basic structure, and basic structure is that structure, that foundation of the constitution on which the entire edifice of constitution is resting. If you remove rule of law, if you remove supremacy of constitution, if you remove secularism, if you remove federalism, if you remove republican character of Indian state, the edifice, agar isko remove kijega, ye niche wale pillars ko aap remove kijega, all these things are down the line, then the entire constitution will fall. So constitution is resting on certain basic pillars. Do not touch those pillars, otherwise you are free to amend any part of the constitution. So actually overturn the verdict of Golaknath, but not in the way parliament actually wanted. Okay, so who was in power 24th April 1973? Mrs. Indira Gandhi. She lost power on 23rd March 1977 when Morarji Desai became the first non-Congress Prime Minister, and 14 January 1980, after 2 years, she again came back with thumping majority. So again 42nd constitutional amendment was brought to overturn the judgment of Keshwananda Bharati कि notwithstanding anything in the constitution, article 368 में जोड़ दिया, parliament has a power, और ये भी लिख दिया to avoid any confusion, Parliament has a power to amend, unlimited power to amend the constitution. This provision was struck down by Supreme Court in Minerva Mills case. That in harmony with Keshwananda Bharati case, Parliament does not have unlimited power. So Golaknath से तो relief मिली, पर पूरी relief नहीं. गोलकनाथ was overturned क्योंकि गोलकनाथ ने तो ब्लॉक कर दिया था. पार्लियामेंट कैन नॉट टेक अवे फंडामेंटल राइट. पर केशवानंद भारती ने कहा नहीं, पार्लियामेंट एक्चुअली कैन टेक अवे फंडामेंटल राइट विदाउट वायलेटिंग द बेसिक स्ट्रक्चर. लाइक सम फंडामेंटल राइट्स हैव बीन डिक्लेयर्ड एज बेसिक स्ट्रक्चर. आर्टिकल 14, आर्टिकल 25, आर्टिकल 21, आर्टिकल 20 इसको बेसिक स्ट्रक्चर कहा है, अदर फंडामेंटल राइट्स को नहीं कहा है. सो आर्टिकल 19(1)(f राइट टू प्रॉपर्टी वाज डिलीटेड बाय 44th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1973, सुप्रीम कोर्ट जजमेंट 1978. So actually after the Supreme Court judgment this happened. Okay, so this is like basic structure of the constitution. So the term law in article 13, in this question has been asked many times and in test series also. Finally, the term law in article 13 includes constitutional amendment or not? The term law in article 13 includes constitutional amendment or not? It does not include. So constitution amendment can take away your fundamental right. Only restriction is it should not violate the basic structure. If a particular right has not been declared as basic structure, then the parliament can amend. Then it will be challenged at Supreme Court and Supreme Court will decide whether that amendment was valid or not. Right to property delete किया गया और Supreme Court ने उसको upheld भी किया है, यानी it was not a part of basic structure. Article 19(1)(f was deleted and now it is not a fundamental right but a mere constitutional right under article 300A. समझ में आ रही है बात? So I think this is enough for the day. I will dictate with a fresh mind केशवानंद भारती versus State of Kerala. Article 13 में इतनी doctrines हैं, all doctrines we'll see, then we'll venture into article 14. Thank you. Have a wonderful evening.